Thank you very much. You may be seated. Ladies and gentlemen, ushers, please assist us with the colleagues who are still at the back. To settle, please. The ushers at the back, let's just minimize the movement and have everyone settled. May I request all of us at this moment to rise for the singing of the national anthem. You may take your seat. His Excellency, Honorable Deputy President, Minister for Justice and Correctional Services, other cabinet ministers that are here, deputy ministers, directors general, the National Commissioner of Correctional Services and the National Commissioner of Police, the National Director of Public Prosecution, and colleagues that are here, all of you, the stakeholders. Good morning. Good morning. Avshen. Dumelang. My name is Doc Mashabane. I'm the Director General of the Department of Justice and Constitutional Development. I'll be briefly be directing the program. Without taking much time, colleagues, as the colleagues at the back settle, if the head of security can just assist with that queue for it to settle. Yes. The chief ushers, please assist us with the colleagues at the back to sit down. Colleagues, welcome to this conference on the Integrated Criminal Justice System and a review of the Criminal Procedure Act 52 of 1977. This indeed is a momentous occasion, particularly this year as we'll be observing and commemorating the 30th anniversary of our constitutional democracy. So we gather here for the next 3 days to discuss the state of our criminal justice system. and the Criminal Procedure Act as its bedrock. So I want to thank all of you for having made the time to come and join us this morning for the next 3 days, and hope that you will find the meeting to be a befitting platform for all of us to make our inputs for the future of our criminal justice system. Without taking much time, I would like to invite the Honorable Minister of Justice and Correctional Services, Mr. Ronald Lamola, to the stage to give an opening address. Minister, I invite you.
Yeah, thank you very much, DG Advocate Mashavane. It is a great privilege for me to be here today to wish you all a good morning and to extend a special welcome to the Deputy President of the Republic of South Africa, my cabinet colleagues, Minister Cele, the Deputy Minister of Justice and Constitutional Development, Mr. John Jeffrey, the Deputy Minister of Correctional Services, Nkosi Pategile Holomisa, the MEC for Gauteng Community Safety, Ms. Faith Mazibuko, all members of Parliament who are here, including the Chairperson of the Portfolio Committee on Justice, the leadership from the Judiciary, Judge President Musi from the Free State, Acting Judge President Goliath from the Western Cape, and the Acting Judge President from the Eastern Cape, Judge President Mpahlele from Mpumalanga, the Judge President from Limpopo, and the other judges who are here that I may not be able to recognize them each by name, and the other Judge President that I might not have seen. Also the former Judge President of the Mpumalanga Provincial Division, Mukoni, Judge Likhodi. He is also the project leader for the South African Law Reform Commission on the review of the Criminal Procedure Act. Also all the regional courts presidents that are here, and the senior magistrates, the National Director of Public Prosecution, the National Commissioner for the South African Police Service, the National Commissioner for Correctional Services, all heads of departments, Director Generals, the National Head for the Directorate for Priority Crime and Investigations, the Chairperson of the Global Coalition to the Fight Against Financial Crime, Advocate Kolisile Kanyile, the head of NACOC, everyone that is here, Director Generals that I might not have seen, the leadership of our Chapter 9 institutions, the Vice Chairperson of the South African Law Reform Commission, Professor Wessels, Domingo, a member of the South African Law Reform Commission, the Chairperson of the South African Human Rights Commission, Mr. Chris Nissan, and commissioners from the South African Human Rights Commission, the members of the legal profession in their representative bodies, academics, research institutions, civil society present here today, and members of the media, ladies and gentlemen. It is a great honor for me to welcome all of you here to this conference on the criminal justice system anchored on the review of the Criminal Procedure Act. Every step towards the goal of justice requires sacrifice, suffering, and a struggle, the tireless extortions and passionate concerns of dedicated individuals. Close quote from Martin Luther King. On behalf of the Minister of Justice and Correctional Services, I extend a warm welcome to all dedicated individuals who have generously given their time to join us in this conference. as we navigate through the post-apartheid era in our fight against poverty, crime, and all relevant injustices. The Constitution is the guiding light and the custodian of all our values. The governing party, the African National Congress, in its 2024 election manifesto, calls for the strengthening of the justice system, including the National Prosecuting Authority, the review of the Criminal Procedure Act, reducing the case backlogs and delays, support the Legal Aid Board to provide fair access to justice, introduce technology to make court procedures more efficient and accessible, and strengthen the protection of whistleblowers. Our journey to transform the entirety of the justice system continued when we mandated the South African Law Reform Commission to review the Civil Procedure Act, which is a project that is also underway, similar or parallel to this one of the Criminal Procedure Act, the Insolvency Act, and the repeal of the apartheid-era legislations, and the Criminal Procedure Act, which is today the subject of this conference, as part of the transformative journey of the justice system and the services that we offer to our country. We look forward to the research papers in all the above-mentioned subjects, and we also look forward, in specific, to the one of today related to the Criminal Procedure Act. A brief background on the review of our criminal justice system includes, amongst others, work done by the South African Law Reform Commission in respect, among others, of the law of evidence in civil and criminal proceedings. For instance, a review of the law of evidence was included in the South African Law Reform Commission's research program after its establishment in 1973. The Commission's original intention was to codify the South African law of evidence in its entirety and consolidate it into one act. However, the Commission gradually realized the enormity of such an undertaking and abandoned the codification of the law of evidence. The Commission decided rather to ascertain which aspects of the law of evidence were unsatisfactory or did not meet the current needs, and to formulate suggestions for their reforms. In 2003, in a preliminary study by the South African Law Reform Commission, Professor P.J. Squickert identified several areas of law for possible reform and outlined this in a committee paper 1024, titled Project Review of the Law of Evidence, 2003. The areas under discussion included the following: the principle of the law of evidence, the approach to hearsay evidence, and various structural features of court system, that is, limited role of lay assessors and the adversarial nature of the proceedings. Paper 1024 recognized that the function of the law of evidence differs in civil and criminal trials, and that there are different policy considerations underlying each. Whereas civil trials are intended to resolve disputes to order relationships, criminal evidence and procedure is an applied branch of moral and political philosophy in which the rights and responsibilities of citizenships are articulated. As a point of policy, therefore, the paper concluded that a more conscious approach should be taken to the admissibility of evidence in criminal trials. That preliminary study was followed by issue paper 26, review of the law of evidence, and discussion paper 113, review of the law of evidence, hearsay and relevancy. Both these papers were published in 2008. Issue paper 26 identified several issues in theory and in practice for further investigation and review. This included issues related to the concepts of real evidence, documentary evidence, and computer-generated evidence. As we build upon this foundation, it is crucial to address the pressing issues of crime and violence in our country. And how will the law of evidence play this role? One of the constitutional imperatives derived from our historic constitution, bestowed upon us by our founding fathers, is the transformation of our criminal justice system. We must acknowledge the damage inflicted upon our society by the brutal regime we overcame, while also ensuring the safety and security of every individual in our land. We must also be able to respond to the criticism in society, including perceptions that criminals have got more rights than the victims. Trust in the justice system will be restored when victims' rights are protected and justice is served. Our communities live in constant fear, plagued by gangsterism, armed robberies, rape, murder. Women and children are particularly vulnerable to the violence inflicted upon them by men. Furthermore, our economy suffers due to damages of infrastructure, extortion at construction sites, corruption, the growth of illicit activities, and the high cost of securing businesses and assets. As we approach the 30th anniversary of our democracy, it is an opportune time for us as a diverse nation to reflect on our criminal justice system in light of the fundamental rights and freedoms enshrined in our Constitution. For democracy to be sustainable, people must feel free and safe. They must also see the Constitution working for them. This conference must help us balance these rights. As early as 1996, the then Minister of Justice, the late Dula Omar, and the then Minister of Police embarked on the transformation project, resulting in the National Crime Prevention Strategy, aimed at moving the criminal justice system from a narrow focus on repressive crime control to one that recognizes that crime does not occur in a vacuum, but emerges in most instances from social ills. The functions or objects of the criminal justice system is to provide a social mechanism with which to coerce members of society to abstain from conduct that is harmful to the interest of society. The modernization of the relevant criminal justice services, from integration of data to efficiency of the forensic services to the use of technology and to deal with the criminal investigation, and to even hybrid witnesses appearance in order to protect victims, and so many other areas of our justice system, which this conference has to address and respond to. We are glad that there's a cross-pollination of experts from the NPA, from the police, the South African Law Reform Commission, judges in our country, and everyone. We are hopeful that this cross-pollination of expert views and opinions will help us shape the Criminal Procedure Act that is compatible to our Constitution post our democracy. Our entire system, from crime reporting to crime investigations and ultimately the judicial intervention and correctional services, need to have an integrated repository of information to ensure that efficiency is sustained. I pause to remind that in our country we have currently cases that last more than half decades in the trial stage, long even before the institution of appeal proceedings. Think of the stress this places on the victims and society at large. Witnesses that plays a role in such trial. It is unsustainable. This conference must also help us to ensure that the criminal justice system expedites and deals with cases efficiently. According to the online journal, Legal Coups, published on the 22nd May 2022, the best legal systems in the world are to be determined using the criteria, including considerations for the rule of law, time frames of judicial decisions, the efficiency of judicial interpretations, that is legal certainty, the role of investigations, the roles of prosecutors and the time frames, judicial officers' availability and the availability of prosecutors and investigating officers, availability of courtrooms, and so forth. For us to succeed, we must measure ourselves against the best in the world. We need to look how we fare in regards to this, including with our rehabilitation programs and correctional services. The time has come for us to reimagine and reassess what we have inherited. By adopting a victim-centered approach, we can create an environment where victims feel supported and empowered through the entire process. We hope this conference will put the victim at the center, because the current Criminal Procedure Act, we have been criticized that it doesn't. The victim's role is very limited in the current system. We have to imbue that and embed the victim's role in the entirety of the chain of the whole criminal justice system. We are thankful that experts in the international and regional arenas will be sharing their observations and thoughts on key challenges facing the criminal justice system and the lessons that we can learn from other countries of the world. As a government, we have sacred duty to keep our people safe and secure. As Bernard Bikerk said, and I quote, "There is no greater threat to a free and a democratic nation than a government that fails to protect its citizens' freedom and liberty as aggressively as it pursues justice." Bernard K. Bikerk stated this from his book, From a Jailer to Jailed, from corrections and police commissioner to an inmate. Our struggle to achieve democracy was a struggle of many. The struggle to protect and to grow our democracy and to prevent and have a crime-free society is a struggle for all. The South African Law Reform Commission has been tasked with the review of the Criminal Procedure Act, and we are thankful that Mukoni, after your retirement, you accepted this task which takes you away from home, but we believe is for the betterment of our country. Much research and investigation has already taken place, and we'll be hearing about the work done over the next few days as we explore concepts such as alternative dispute resolution in criminal matters, the use of lethal force in effecting arrest, the bail provisions, and the pre-trial procedures, and the processes to ensure the right to a fair and a speedy trial is upheld. Our engagement and the discussions on the thematic areas that will be presented will offer critical insights and recommendations to inform the work being done on the criminal procedure reform. This is a project that will require the constructive engagement of society and those institutions that play a key role in the criminal justice system. There's much to be done over the next 3 days, because we hope that at the end of this conference, we must be able to come up with a new draft bill on the Criminal Procedure Act. And you are here to help us do that. I'm looking forward to your robust debates and discussions as participants from academia, civil society, and government engage with the presentations delivered by the experts over the coming days. And hopefully that these discussions and debates will culminate in concrete recommendations. I will end off by welcoming you once more and wish you a productive, enlightening, and a successful conference that will reinvigorate and re-strengthen our criminal justice system. Thank you very much. Thank you very much. The DG has just reminded me of my next task. Firstly, we have invited the entire criminal justice cluster. The cabinet committee in the cluster is chaired by the Deputy President of the Republic of South Africa, Mr. Paul Mashatile, who has been a leader of the ANC, a chairperson of the Gauteng province of the ANC. He has also been a member of parliament. He has also been a minister of arts and culture. He has also been the Treasurer General of the African National Congress. He was elected in 2022 as the Deputy President of the ANC, and subsequently he was appointed as the Deputy President of the Republic of South Africa. I will request that we stand up and welcome the Deputy President to give us a keynote address. Deputy President.
Thank you very much. You may be seated. Let me also thank the Program Director, our Director General, Minister of Justice and Correctional Services, of South Africa, Honorable Ronald Lamola, Minister of Police, Honorable Becky Cele, Deputy Ministers, John Jeffries, Pategile Holomisa, MEC for Safety in Gauteng, Ms. Faith Mazubuko, members of the Parliamentary Portfolio Committee here present, former Judge President of Mpumalanga, Justice Luhodi, Judge President of the Free State, Justice Musi, and other judges here present with us today, former and present judges, head of commissions here present, National Director of Public Prosecutions, Advocate Shamila Patoi, National Commissioner of the South African Police Service, Lieutenant General Fani Masemola, Mr. Mahoti Samuel Tubakale, Department of Correctional Services, National Head of Directorate for Priority Crime Investigation, Advocate Lieutenant General Godfrey Libia, National Head of Directorate, Senior Leadership of Chapter 9 and 10 institutions, traditional leadership and civil society organizations here present, government officials, members of the media, ladies and gentlemen. Dumelang, Sanbonani, Abshe, Dimachero. I am honored to address you today at this important conference that brings together stakeholders to contribute to the National Development Plan 2030 vision through honest review, solution-based recommendations, and a commitment to working together towards a South Africa with a strong criminal justice system, a country where all feel safe and secure. As we celebrate 30 years of our Constitution, with less than 3 months to the 2024 general elections, this is an opportune moment for us to reflect on the criminal justice system in the context of the rights enshrined in our Constitution and the founding provisions of human dignity and the advancement of human rights and freedoms. I believe that the criminal justice system serves as a bedrock of every democratic society, ensuring the protection of individual rights and the maintenance of order. For many years, the Integrated Criminal Justice System and the Criminal Procedure Act of 1977 have had a profound impact on how we handle law enforcement, prosecution, and adjudication in South Africa. However, we must examine the current legal framework and identify areas that require transformation and amendment. Our laws must be responsive to the changing needs of society and aligned with international standards. In this regard, our Constitution guides us on the ongoing path of transformation, which has proven to be dynamic, challenging, but also producing some positive outcomes as it relates to improving the lives of all South Africans. Likewise, the criminal justice system and all its constitutive parts are on a transformative journey, requiring us to assess where we come from, where we are now, and where we are headed. Currently, our criminal justice system and democracy have been put to the test due to widespread corruption, criminality, gender-based violence, and femicide. Crime remains persistent, despite the many strategies we have devised to fight it, such as increased police presence, community policing initiatives, and technological investments in surveillance and evidence collection. The prosecution and judicial system are overburdened. The correctional services is overcrowded, and the police system continues to be besieged as the state fights to prosecute and punish criminal behavior, frequently compromising on zero-tolerance pledges to punish at all costs. Looking at these challenges, it is easy to grow despondent, but we must never be discouraged. Instead, we must double our efforts to reach our desired goals. The legal system in South Africa has undergone significant changes since the apartheid era, aiming to ensure fairness and equal opportunities to all citizens. Post-1994 changes include a national crime prevention strategy, victim empowerment programs, and a diversion program for low-impact offenses under Pillar 1 to ensure human rights culture. Recently, we replaced the 1996 National Crime Prevention Strategy with the Integrated Crime and Violence Prevention Strategy, approved in March 2022 by the Cabinet. This strategy focuses on preventing crime and violence through the whole of government and the whole of society approach. It outlines a comprehensive collaborative framework for crime and violence prevention in the country, focusing on 6 independent and interrelated pillars, which are the following: an effective criminal justice system, early intervention for crime prevention, victim support interventions, effective and integrated service delivery, safety through environmental design, and active public and community participation. I applaud the implementation of the Safer Cities project in 7 cities, which includes community participation with more than 58,000 community in blue patrollers, and the continuation of programs such as traditional policing and the NPA Community Prosecution Initiative. Furthermore, we applaud the growth of Thuthuzela care centers, which now have 63 locations targeting high crime areas, empowering community policing fora, and implementing outreach projects. Ladies and gentlemen, we cannot overlook the issues that are endangering our economy, particularly in the construction sector. Murderous construction mafias have brought many companies to their knees, and we must fight back to safeguard this industry. A concerted effort from all is necessary to unravel the complex web of construction site disruptions, which endangers lives and impedes the government's objective of transforming the nation into a massive construction site that generates employment and expands the economy. In this regard, the economic infrastructure task teams are actively working to combat non-ferrous metal thefts, essential and critical infrastructure crimes, and illegal activities in mining. They emphasize the need to enhance existing interventions to safeguard economic infrastructure with a particular focus on state enterprises, particularly Eskom, Transnet, and PRASA. As government, we have put fighting crime and corruption as a top priority because it undermines human rights and the rule of law. We are tackling significant commercial and serious organized crime through the developed anti-crime task team and the Directorate for Priority Crime Investigation Operational Committee, currently known as the National Priority Crimes Operational Committee, under the South African Police Service Act. Through the integrated task force, we are coordinating the implementation of more than 200 recommendations for criminal investigations made by the Zondo State Capture Commission. As it stands, 3 convictions secured and 11 cases are currently before court relating to 36 recommendations. The remaining recommendations are still under investigation. Despite these crime intervention strategies and other initiatives, it is concerning the most recent Statistics South Africa Victims of Crime Survey indicates that confidence in our criminal justice system is declining. In other words, our people do not feel safe and secure. As a result, over the next few months, the JCPS cluster is strategically planning key interventions from multiple departments to address the prevailing crime situation. These efforts will notably focus on combating violent and organized crime, with a dedicated emphasis on addressing corruption, amongst other things. Maintaining targeted efforts to address gender-based violence and femicide and its impact on individuals and communities. Establishing an independent entity called the Investigating Directorate Against Corruption with the National Prosecuting Authority, NPA. Enhancing the effectiveness of the Whistleblowers Act. And also finalizing revisions to the Criminal Procedure Act to bolster efforts to combat both crime and corruption. Ladies and gentlemen, given the drastic impact that arrests can have on the fundamental rights of individuals and the potential harm to those arrested unlawfully, it is imperative to reduce the instances of unnecessary arrest that may lead to unlawful arrest and detention. Promoting alternative methods of ensuring a suspect's court attendance, such as summons, written notices, is crucial to reduce costly civil claims against the state and address pressing needs. Ensuring these methods are more accessible to police officials and considering greater judicial oversight over arrests is also necessary to reduce unnecessary arrests. This will indeed help the strain on the fiscus and improve the overall justice system. A couple of years ago, in response to the incessant outcry by our people that bail is readily granted to accused persons, the government undertook to review bail laws to make it more difficult for accused persons to be released on bail. Consequently, the Minister of Justice has initiated a review process to strengthen bail laws, ensure national security, and address some of the concerns of victims and communities as it pertains to our own processes. This review is a central part of our ongoing work by the Department of Justice and the South African Law Reform Commission. We believe that the outcome of this review will make sure that bail decisions are based on the needs of victims and complainants as well, improve the effectiveness of our efforts to fight crime, and address the problem of overcrowding in our prisons and remand detention centers. Regarding gender-based violence and femicide, we have developed the Gender-Based Violence and Femicide National Strategic Plan to enhance a unified national response to this issue. In 2022-23 fiscal year, the courts have shown a 27.9% increase in life imprisonment sentences for gender-based violence and femicide at Tutuzela care centers, indicating the court's robust approach to combating gender-based violence and femicide. Most significantly, the National Assembly approved the Gender-Based Violence and Femicide Bill, which is currently under scrutiny by the National Council of Provinces. The government is responding swiftly to the gender-based violence and femicide epidemic by putting an emphasis on robust institutions and solid evidence. In late 2020, the Department of Justice introduced 3 amendment bills, including the Criminal and Related Matters Amendment Act 12 of 2021, the Criminal Law, Sexual Offences and Related Matters Amendment Act 13 of 1921, and the Domestic Violence Amendment Act 14 of 2021. The latter act established an electronic repository for domestic violence protection orders, which became operational on the 14th of April 2023. These laws significantly change the legislative framework for gender-based violence, emphasizing the need for an effective and efficient criminal justice system to fight gender-based violence and femicide. Ladies and gentlemen, regarding immigration, South Africa has various pieces of legislation that address citizenship, immigration, and refugee protection, including the Citizenship Act, the Immigration Act, and the Refugees Act as amended. There is some misalignment in these pieces of legislation. Government has thus began to do an evaluation of these existing laws and create new laws that will assist in dealing with this crisis of illegal immigration in our country. I'm confident that the recently approved Cabinet White Paper on citizenship, immigration, and refugee protection will provide a framework for granting residency and citizenship to foreign nationals and protecting refugees and asylum seekers while keeping the Republic's national security interests in mind and following international migration agreements and protocols to which South Africa is a party. Minister Lamula and all the highly esteemed participants, let me conclude by highlighting that the formation of independent judicial institutions devoid of political influence has been one of the most significant achievements of the democratic South African justice system. This has guaranteed that the courts can carry out their roles in an unbiased and fair manner, protecting the rights of every person. The judicial system has also played an important role in resolving historical injustices through mechanisms such as the Truth and Reconciliation Commission. These activities have served to promote healing and reconciliations among South Africans, opening the path for a more cohesive and inclusive society. As we look towards the future, let us commit to further enhancing and protecting this crucial institution to ensure a just and fair society for all and for all South Africans. I'm optimistic about the potential outcome that will emerge from this conference discussions, which will ultimately shape the ongoing evolution of our criminal justice system. Program Director, let me thank you for this opportunity. I did indicate to Minister Lamula that I would have liked to be here until lunchtime to participate in the conference and hear other inputs, but unfortunately there are commitments I couldn't get out of with the IEC, so I will not be with you until lunchtime, but I wish the conference all the best. Thank you very much. Ken Sainko.
Councillor Snene DP, and I will want to ask the Deputy Minister for Justice and Constitutional Development, Honorable John Jeffrey, to come and express a word of gratitude to the Deputy. Thank you very much.
Thank you, Program Director, Honorable Deputy President, Honorable Minister, all distinguished guests and friends. The National Development Plan 2030 not only articulates a vision of the type of society which each and every person in South Africa wants to see realized, it also sets out a roadmap for us on how to achieve it. As we celebrate 30 years of our democracy, this is an opportune moment to reflect on the criminal justice system in the context of the rights enshrined in the Constitution. It is time for us to look critically at the criminal justice system and see where it works and where improvements need to be made. Often people think that laws are set in stone, old and traditional. But the thing about good lawmaking is that laws should not be static. They should change as society does, meeting the needs of users of those laws. And that is why we also need to look critically at the Criminal Procedure Act, an act which, although has been amended many times, is nearly 50 years old. Achieving the vision of the National Development Plan requires a well-functioning criminal justice system in which the police, the judiciary, and correctional services work together to ensure that suspects are caught, prosecuted, convicted if guilty, and securely incarcerated and rehabilitated. An effective criminal justice system is a necessary condition to promote safety and security effectively, but it is insufficient on its own. Partnerships with other key stakeholders are vital. More is required from us to find sustainable and effective solutions to crime and insecurity. Active citizenry, an efficient criminal justice system, and effective coordinating partnerships with civil society and the private sector are key components of a sustainable strategy for the safety and security of our people. Inspiring public confidence in the criminal justice system is necessary to prevent crime and to increase levels of safety. Public confidence is eroded by perceptions that criminals escape the law, that bail laws are not properly applied, that arrests do not lead to convictions, that prisoners escape from courtrooms or correctional facilities, or that people who shouldn't get parole get parole. Public confidence is also eroded where the victims of crime feel that they're not supported or treated well by the system. And that is why it is vital to have a criminal justice system which responds to the needs of the victims of crime. This conference will bring together all stakeholders who contribute to achieving the vision of the National Development Plan 2030 through honest review, developing solution-based recommendations through engagement, and committing to work together to achieve the vision of a South Africa where all feel and are safe and secure. I want to extend a sincere word of thanks to everyone who has already or will be contributing to the success of this conference over the next 3 days. Firstly, I want to thank the Deputy President for an insightful address. Mr. Deputy President, your address has once again highlighted government's ongoing commitment to strengthening the criminal justice system, and your attendance this morning sends a strong message that government is serious about fighting crime and building safer communities and building a criminal justice system which instills public trust and confidence. I want to thank our Minister, Minister Ronald Lamola, for his leadership, and I want to acknowledge and thank the various ministers, thank in advance sometimes, the various ministers, deputy ministers and members of parliaments for their inputs into this conference and the process going forward. To the members of the judiciary, we can all truly say that our courts have been the bedrock of our constitutional democracy. Our courts have been fearless in their judgments, holding even the most powerful to account. Thank you also to the representatives of our Chapter 9 and Chapter 10 institutions. For those of you who don't know about Chapter 10, it's the Public Service Commission. The fact that these institutions have such prominence in our Constitution shows the importance with which the architects of our democratic dispensation viewed these bodies. To our international partners, those in the diplomatic corps, and from international organizations, thank you for your unwavering support and assistance to the work we do here in South Africa and in the region. A special word of appreciation to members of civil society who are here and will be participating in this event. The National Development Plan acknowledges and places a high value on active citizenry, and we're extremely fortunate as a country to have the vibrant civil society sectors that we have. To the people who are at the very coalface of the criminal justice system, such as the National Director of Public Prosecutions, the senior leadership of the National Prosecuting Authority, of the SAPS, and of other JCPS government departments, Legal Aid South Africa and the legal profession, thank you for the work you do, often under challenging circumstances, and for being here to share your insights with us. I also want to welcome and thank the members of the media. Many of you report on crime and criminal justice matters every day. Often you are the ones who ensure that the public know who the victims of crime are, what happened to them, and you are the ones that make sure their stories are told. Last but definitely not least, let me welcome and thank the leadership of the South African Law Reform Commission. The Commission is fundamental to law reform efforts in our country, and were it not for the Commission, along with our department's legislative drafting branch, this conference would not have taken place. I want to acknowledge all the hard work you have done thus far and wish you the best for the process going forward. Program Director, the conference will foster robust discussions and debates to cultivate ideas and solutions to the challenges faced by the criminal justice system in South Africa. We owe it to those who paid the ultimate price for the freedom we enjoy today to ensure that we have a criminal justice system which works and works well. Thank you.
Thank you very much, DM. Just in that list of gratitudes, we finally also want to thank God for the good weather today. It has been very hot in our province or in our country the past 3 days. We are on good time. I want to, at this moment, ask all of us to rise to our feet and allow the Deputy President and entourage to take leave as we remain standing, and as the Program Director, I will give you direction. Deputy President and Minister. You may take your seat. You see, I'm now in charge. They have left, so I'll properly direct you now. Okay, in terms of our program, 10 o'clock, which is 1 minute before 10 now, I use the best watch in the world, it's always on time. We're gonna break for 30 minutes, colleagues. Let's break for 30 minutes and be back here 1 minute before 10:30. So at 10:29, we should all be seated. I understand, where is the coffee stations? Okay, outside to my left. Okay. I take it that smoking is banned in Beechwood Hotel, so there won't be a smoking corner. Okay, we are promoting healthy living and discourage slow suicide in the form of nicotine consumption. Okay, we will take a break now. To our left, there will be coffee stations there, and let's get back here at 10:29 to proceed with the program. Thank you very much. Colleagues, we are calling you to order. Can we get started? Okay. We'll proceed, ladies and gentlemen, with our program. Just a slight adjustment. We are taking the second panel instead of the first panel, so we won't be assessing the integrated criminal justice system and international perspectives on crime fighting. We will take the second panel that looks at governmental performance in the integrated criminal justice system. As you know, there's a sitting at 2 o'clock, so the honorable ministers have to take leave in order to be in attendance in Parliament. So we'll take that panel now to deal with the integrated criminal justice and the performance of government since the adoption of the national crime prevention strategies. And the focus will be on the 4 pillars in broad terms, in terms of how we have performed. The 4 pillars of the national crime prevention strategy: number 1, the criminal justice process needed to be more efficient and effective and provide a sure and a clear deterrent for criminals and reduce risk of reoffending. Pillar number 2, reducing crime through environmental design, focusing on designing system to reduce the opportunity for crime and increase in ease of detection and identification of criminals. Pillar number 4, public values and education initiatives are required to change the way communities react to crime and violence. Pillar number 4, transnational crime combating programs should improve the controls over cross-border traffic related to crime, thereby reducing the impact of international criminal syndicate. We'll want to apologize for one panel member, Honorable Minister Aaron Motsoaledi, who is currently in the Portfolio Committee in Parliament and is not able to join us for this program. Ladies and gentlemen, without wasting much time, we also have supporting panelists who are seated on the floor, and the supporting panelist is National Commissioner of Police, General Fani Masimula, and National Commissioner for Correctional Services, Mahoti Tubakale, and the National Director of Public Prosecution, Advocate Shamila Batoy, and have I left anyone here? So they will make an intervention from the floor for any questions that will be raised. Without taking much time, I will start with the Minister for Police, Honorable Becky Cele. There's a microphone, Minister. I'm not sure you prefer to be here. It might be better here. I will invite the Minister to kickstart the discussion. Thank you very much.
Kickstart, ne? Morning, Program Director, Director General, the Minister, Deputy Ministers that are here, the judges, a lot of them are here, and magistrates, okay, and magistrates. Last time I'm before the judge and magistrate, I was sent to prison, so I don't want to spend a lot of time before them. The colleagues and everybody that is here, I listened to the keynote address by the Deputy President and the welcoming address by the Minister, even the vote of thanks by the Deputy Minister. They were all rich. From the side of the South African Police Service, we don't have much on this one. We have few to raise. There are things that we want to confirm and agree with when it comes to the opening remarks. But I want to start here, Minister Lamula, that for last reporting quarter of the South African police, which is 3 months, that will be October to December, we lost 22 police in South Africa in 3 months. 22 police were killed, 10 of them on duty, 12 of them off duty. If I'm not mistaken, this is a 7th or 8th weekend since the year started. I've attended 5 funerals of the South African police members killed already on those 5 weekends. Our call, as I would now and again touch base with you, Minister, is that human rights must be respected. All of us, we must remember that we are policing and working and we're enforcing under this kind of dispensation, under the Constitution and under the present situation that is completely different from the apartheid. But I always remind all of us to say police are human, so they have rights themselves. So as the law is done, I would really want to see protecting the members of the South African police. There's been a call, especially from the labor unions and the community in general, to say the law must protect the law enforcers adequately. Sometimes there is a feeling that criminals are more protected than the law enforcers. Well, you call it perception. I don't know if it is a perception, I don't know if it's a feeling, I don't know if it's reality. But as this law, Criminal Procedure Act, is developed, we wish it takes that one on board, that the law enforcers, basically South African Police Service, as I stand here, members and others, they found some cushion in the law. There is Section 49 with using force and all that. I don't know if that is going to be there, but I would love that their cautioning is extended. Not give them the powers to be abused, but not also allow them to protect their own lives. There is a call of which can be correct, but I also want to make a point to say members of the South African Police Service, their life cannot be above the citizens of South Africa. But it must be also understood that they stand as a buffer between criminality and the whole society. If they are pushed to the brink and they fall, these criminals, they walk over the community thereafter. So it's important to understand that police and law enforcers, they are given some leeway of extra protection when they deal with criminals. Criminals, they are on the lucky side. Criminals don't have auditor generals. When you use your money as a member of South African Police Service, you still have to explain that money. They don't explain their budget. That's why they've got a better budget and more flexi budget than the law enforcers. Criminals have flexi budget. Criminals don't have borders. If we need to send the police to pursue a criminal, we must get a passport, we must get a whatever other document. Criminals, they come and go. So the law must find some flexibility of the law enforcers able to have a hot pursuit to find those criminals wherever they are, working with the neighboring countries and all that. Criminal cross the border and the law enforcer need to stand and stop on that particular one. But also, having moved around and dealing especially with these funerals, including the funeral that we had last Saturday of a 37-year-old constable with a 4-month-old daughter in the arms of the mother. The community feels, either as perception or as a feeling or as a reality, that our system is more sympathetic to perpetrators than victims. They will give you this narrative that if the criminal shoots you, DDP, and you die, the first thing your children will get out of the school of choice, they won't be able because you are gone. Their car that you have bought them will be repossessed. Their house will be repossessed. Their education will be disturbed. But the criminal, the first thing that does is to warn the lawyer that the very same victim has paid for through the tax money. Starts there. And if it happens that the criminal gets hurt in the exchange of fire, will be taken to the best medical care that has never been before and will demand that I want to go to that hospital. When your children, they lose the medical aid and they can't go to the hospital of their choice, the criminal will go to the best medical care. Second, when the children cannot use hot water to bath because they can't pay the bill for electricity, the criminal will be given by Ministry of Correctional Service and his DG warm water to bath in the morning. When the child of the deceased doesn't have food because there is no man of grocer, Lamula will be giving them 3 meals a day. When the child can't finish the degree because nobody to pay for the education, the criminal will be getting PhD because Lamula will be allowing them and going to congratulate them for passing very well. These are the things when you go to this funeral and the communities engage you. These don't come from you. They come from the community that engage you. And you begin to realize that but as a government, we're not lucky to walk this path until you meet these communities. And when you look at these things, you realize that communities have genuine takes on these matters. Therefore, the call is that can we create the system, starting with the laws, that protect victims more than protecting perpetrators? If our laws can go this way and thus far to protect our victims rather than perpetrators. The other one that keeps coming is a protection of the whistleblowers, but also the protection of witnesses. From the side of the South African Police Service, we are more concerned about the witnesses, because if the witness falls off, then that case falls off. And I know that both prosecutor, but IO is the best day when the judge or the magistrate saying, I find you guilty and I'm sending you to prison for life. I've seen police, how they feel. But when the case falls off and is withdrawn and all that, you can see the pain on the IO again. So it's important that all processes are kept in place so that when the day comes for the magistrate or the judge to pronounce, we're all happy. So it's one area that the protection of witnesses should be taken on board. Fortunately, our cluster, the JCPS cluster, is working much better now. Together we talk about those things. But we would love to see the law really getting tight on protecting witnesses. Sometimes witnesses, they feel that we don't take care of them. When sometimes they lose everything. There are witnesses, by the way, that lose everything for us to win the cases. So it will be important that the laws, could be this one or any other law, to make sure that those that they were there who are prepared, because the witness can simply say, I'm not part of it, I don't want to be part of it, and your case falls. If you say you leave your house, you uproot your children, you go to a new place, you go where nobody knows you, you hide every day in your life and all that, but you're still in the broken house, nobody takes care of your kids and all those. So I think it's one area that we must work big when it comes to the witnesses, especially those that they volunteer to be witnesses of serious crimes. So that's one call that we'll make. Our last contribution is that police work hard to arrest you. We don't just wake up in the morning and say, you know, today I want to arrest him. No. No. Sometimes there are big questions and big pressures. Why don't you arrest so-and-so? Why don't you arrest so-and-so? Why don't you arrest so-and-so? There is one big one as we speak now of AKA. That's a big one. But also is a big problem when you arrest and let go. So one thing that we'll really request is that we do better on bail issues. Let's do better on bail issues. You know, as I stand here, we have 64 CIT guys that are on bail. That is cash heist. I know them by name, Abo Gifty, Abo Boy, and I know them. Now, I have raised it because a person who leads this process is here. Judge, what happens? The police arrest a CIT guy, well known. I can give you the list of them. Well known. We go oppose, and the guy doesn't get the bail. But the lawyers and some prosecutors, they take that case to a small court that is not known somewhere at Makabatini as a new bail, and they don't tell the story. And that guy gets the bail without the IO in court. And the IO meets somebody walking on the pavement. Say, what was that? I'm out. There are so many bails that they come from these small courts. I think the coordination from the judges, big courts, small courts, will have to be better. Maybe we are also guilty as a cluster of not putting systems to tell us the story that this decision has been taken there, this decision is, so to go on buttons to know exactly that this person is not coming in court for the first time. But that's one big problem of this bail, of the crime, of the cash heist people, and the high profile criminals that are out there. Bail, bail, bail. And I can assure you, once they are on bail, they repeat it. But also, people that get bail time and again, they encourage vigilantism. Because people will say, it's no use, man, because you go to court, you come back next day, you go to court, and people take law in their hands. On things that cause matter now, vigilantism has become that. Most people, they die, and the reason is arguments. South Africans can't talk to one another. South Africans can't listen to one another. Major thing that people, they die out of are arguments, especially when they come out of ship-ins. That's why they die, more people they die Saturday, Sunday, Monday morning, around ship-ins, and after they've drunk, when they're drunk, they can't reason, so they shoot one another, they stab one another. But they go and get bail, and community takes those things in their own hands. And vigilantism, they ban them, they throw stones and all that. So the bail issue is one issue that we'll have to look. So rounding up, please, this law, take the safety of law enforcement on board as you do it. Don't make them rookies, don't give them extra power to do as they wish, but protect them, understand that they are the buffer between citizens and the safety of citizens and criminality. So give them the extra protection. The law must do so. Secondly, our witnesses must get better protection and better understanding and better value of them being there and dealing with us in terms of helping us to win crimes or to win processes in court. Thirdly, bail should not just be dished like hot potato, like hot scones. Bail must not be dished like hot scones. Really, we must find some way of dealing with the bail situation. I know that we are putting a lot of pressure on the other system as the police. We came with something here that's called Operation Chanela that we launched on May last year up to this point. We have arrested 442,000 people in 12 months. That is beyond the 44% overpopulation of correctional centers. We have arrested 442,000 of them. Lamula complains so much about it. But we say, Lamula, nothing we can do. It must be only criminal. We arrest the criminal. See what to do going forward. But we are glad that we try to work together as a system. But we also want to be thankful to the President that he does realize that it must be the whole system rather than one segment, because ourselves we've been really working on silos. But now we realize that the first segment must speak to the second, the third, and the last segment that happened to be a correctional service. A correctional service is a story for another day. I saw Ngabako here, the spokesperson for correctional service. So when he speaks, I always laugh at him because he speaks about things that sometimes I know that they are even worse than what he speaks about in correctional service. That's the request from our side as a South African police, that let's tighten up these things and be able to allow the whole cluster to work as a cluster, including the document that was quoted by the Deputy President, that is an integrated approach in preventing the violent crime. I want to pick up just one element on that one out of 6 pillars. Let me pick 2 and I sit down. The first one is the early intervention. This early intervention, for instance, Minister of Basic Education will go and celebrate 500 or 450,000 to 500 students that have passed matric. But when you check, there were 1 million when they started. Where is another 500,000? Where is another 500,000? The PPA, I went to Hanover Park. As you know, it's a hot spot, Hanover Park, as we speak now. I went to a meeting. It was Tuesday at 11. There were more kids in the meeting than their parents. It's a Tuesday, it's a school day. They are there. They did not go to school. And I'm telling you, the fast gangs, the JCPS gangs, the killer gangs are very happy to see those kids out of school at 11 on Tuesday. They are fertile ground for them to recruit. So if we don't have this intervention of keeping them at school, of keeping them where they're supposed to be, they are there to be taken on by criminal gangs at Cape Flats, both African and Kala Township, as that is known that those places are infested of gangs. That is one thing. The early intervention must be really one of the biggest issues to prevent criminality. The last point on that one is a design, environmental design. It might not be you as we're sitting here. But as the police, we always complain about this environmental design. There is a place here called Deep Slot around here, Gauteng. But if you go to Cape Town, there is a place called COVID-19. There's a place in Cape Town called sanitizer. There is a place called social distance. I don't know how many of us have walked on these places. COVID-19 was just an open place, but in 2 days it was packed. It's a place, no electricity, no pollution, no water, no passage, no lights, no nothing. If you go there and you say to the police there's a crime in certain place, police will never find that place because there is no address, there is no house number, there is no road leading to that. So environmental design kills policing because you can't respond knowing where you are going. If it happens at Camps Bay, if it happens at Bishop's Court, they'll give address that is Prinsloo Road, number 55. And in the number at the gate, there is light. As you drive through, you will see the road, you will see the number, you will see the house, you will respond. But if you say, take me to Khayelitsha, you will go around Khayelitsha until next morning, having not found the place. So to us, design, environmental design, people building schools, people building housing, putting proper roads, putting proper lighting, and all those kind of things will be a good thing for policing. That will definitely reduce crime. So let's work together as across the board to reduce crime. While police are at the hard end of leading it with all law enforcement, but all other departments and all of us, we can make better to reduce crime and make South Africans feel better. Thanks.
Thank you very much, Minister. I didn't tell you how much I had allocated to you, but you were just 1 minute before your time. So don't feel guilty. You were within your 30 minutes. Thank you very much, Minister. Minister raised an issue of one person granted bail in this court, go to an obscure place where the magistrate doesn't know, anyone doesn't know that he was granted bail somewhere else, and he gets granted another bail. But if you look at the 7-point plan, it talks about integration of the system. So in one of the days in a session in the conference, we'll have an opportunity to look at the integrated system, looking at technology. But with us here on the panel, we have a speaker who will address the use of technology in the fight against crime and using the experience of the United Kingdom. And that panel member is none other than the High Commissioner of the United Kingdom to the Republic of South Africa. For those of you, unlike me, who have never been diplomats, sometimes you get confused about an ambassador and a high commissioner. So, Commonwealth countries, about 57 to 60 of them, we use the high commissioner title if you are sent to a Commonwealth country. But if you come from a country outside of the Commonwealth, you are the ambassador. So that's the difference. Don't be confused thinking it's something for highly educated people. As long as you know the Commonwealth countries, So if we send a person to Nigeria because it's a Commonwealth country, that person is called a High Commissioner. Someone from Nigeria here to South Africa is called a High Commissioner. But if someone comes from Brazil because they are not Commonwealth, is an ambassador. But in terms of the protection, the benefits and everything, they are the same. High Commissioner Anton Philipson, I have the honor to invite you to come and share with us the experience of the use of technology in the fight against crime in the UK. Thank you.
Thank you very much indeed. I think I have a presentation, since I'm talking about the use of technology. But if it's anything like our normal technology, there we go. Brilliant. Thank you very much. DG Mashabane, Minister Kele, Minister Lamola, there are many, many times in the life of a diplomat, especially the life of a High Commissioner or an ambassador for that matter, where you feel like a complete fraud and you have what we call imposter syndrome. And I'm suffering deeply from that this morning because of having the privilege to gatecrash the panel with these two esteemed ministers. But I'm also absolutely delighted to have the chance to talk to you about the topic on the screen, which is leveraging technology and fighting crime in the United Kingdom. And I'm immensely grateful as well, if I may just say, to the programme organisers for rejigging the programme not once but twice to allow me to take the time to speak to you, because I also have to be back in Pretoria just after lunch. But the reason I was so keen to come and spend some time talking to you at this extraordinary conference is because I and the teams that I have the privilege to work with across South Africa as the British High Commissioner are so deeply committed to the partnership that we have with so many of you here today to enhance South Africa's criminal justice system. This is simply an integral and fundamental part of our wider ambition to see South Africa and the UK working together in all manner of ways to deliver for the British and the South African people, and indeed working together for the people of the region, the people of the continent and the people of the world. Tackling global challenges, creating jobs, enhancing trade and investment between us, promoting inclusive economic growth, addressing issues in our community like ending gender-based violence and femicide, supporting a greener planet and indeed creating a fairer society as we do so. This is a partnership that is necessarily multifaceted and multi-layered. It requires hard work. It requires forensic scrutiny, capacity building throughout the policing, investigative, prosecutorial and judicial processes. And it requires patience, diligence, and as the Minister has just said, no small measure of courage from those who are involved at all levels. So I would like to start by commending the efforts of those here today and many others who are not for their efforts in helping to keep the people of South Africa safe and the partnerships that they have with us. And I'd like to say thank you for that partnership, unsung as it so often is. I say it requires patience because we know that the criminal justice system structures and arrangements typically change slowly over time. Quicker and more radical changes can happen at critical junctions where political, social and cultural changes align, but they don't always do so. So it requires effort to bring them together, and this conference presents such a moment, and the UK is grateful to have the chance to share some lessons from our own experiences of reviewing our criminal justice system. So this presentation, for which I'm very grateful for the contribution of my much more expert colleagues, focuses on how we use technology in our criminal justice system to prevent, combat and control crime. Just before delving, though, into how technology can assist our criminal justice agencies, I just want to provide a very brief overview of the UK's criminal justice system. I've done that bit. So, from a UK governmental perspective, and as I just mentioned, criminal justice is often conceived as a system with many different component parts, in which cases flow from one part, the police, onto prosecution, then the courts, and then the correctional services. Different approaches have been pursued over time. The basic structures of our contemporary police service and prison system were laid down during dramatic changes brought on by 19th century industrialisation and the rapid growth of cities across the United Kingdom. But these systems have, of course, undergone significant changes over the years to become what we have today. And the criminal justice agencies, the various criminal justice agencies, all have separate and distinctive functions, but operate towards that common overarching goal of crime control. And in the UK, the main criminal justice agencies are the police, of course, responsible for the prevention, detection, and investigation of crime, The police and crime commissioners oversee most of our police forces in England and Wales and are responsible for commissioning the majority of local support services for victims of crime in conjunction with their local police forces. We have the Crown Prosecution Service, which we have a member based here in South Africa, working with the NPA and others, and they are the primary criminal prosecuting authority in England and Wales. His Majesty's Courts and Tribunal Services can be divided into lower courts and higher courts. The lower courts are composed of the magistrates' courts, where all criminal offences will start off. The higher courts are composed of the Crown Court, which deals specifically with more serious forms of offences. We have the Prison Service, charged with dealing with offenders convicted and sentenced to a custodial sentence. And then we have the Probation Service, charged with dealing with offenders coming out of prison and their aftercare, their rehabilitation, their reintegration into society. And our major UK criminal justice institutions, with the exception of the courts, face regular scrutiny by independent inspectorates. And then beyond the formal mechanisms of inspection and complaints, a diverse and various set of civil society groupings and institutions offer important channels for challenge, accountability, and citizen engagement. The police, the prosecution, courts, prisons, and probation services across the UK have always had a difficult task as they have to constantly deal with increasingly complex case types, managing lengthy case backlogs that built up during the pandemic, while striving to deliver better experiences for citizens and victims to meet citizen expectations. And for this reason, the criminal justice agencies have sought to adopt technology to assist them in addressing these continuous challenges. So as we turn to the evolution of technology in our criminal justice system, this is not new. Technology had already been making its way to frontline police officers in the 1980s, when we saw the prevalence and the distribution of radio systems. Although they were heavy, they had limited range, but they were used to disseminate information, but very limited, as I say, in their reach and their versatility. The new millennium and the explosion of technology in all forms of our lives saw widespread adoption of personal computers by the police forces, which allowed officers greater access to information and enabled them to make better decisions. But lack of mobility continued to remain a problem. Now, of course, technology is no longer just a back office function, but an important pillar in driving operational excellence. Online databases, email, video conferencing applications, automated number plate recognition are all just some examples of technologies that at one time were advanced and novel, but are now in common use across our criminal justice agencies. And more recently, the police have adopted the National Policing Digital Strategy 2020 to 2030. So while the technology available to criminal justice agencies may have changed, and as I say, in some cases radically, their functions continue to remain the same: to maintain law and order, instill a sense of security and confidence amongst our citizens, and to build and retain a capable and committed workforce. Looking just quickly at some of the types of technology that we have used, advanced technology, especially those which use algorithmic or machine learning technology, new tools and capabilities are being introduced to help our criminal justice agencies every day to work more effectively and efficiently. Some of the types of technology include smart CCTV systems that can use machine learning algorithms to identify potentially dangerous situations on our streets in real time, data analytics and the use of a tool called ClickSense for crime forecasting and geomapping crime. And a police officer can use this to see an increasing crime trend in their area and find out quickly what crime types are driving that increase, along with the specifics of the relevant events that then guide the response. We've also seen the creation of a bot to run procedural checks on vetting inquiries, passing key information to an officer for assessment and decision. The use of a harm assessment risk tool, which uses data analytics and machine learning to provide a prediction of how likely an individual is to commit a violent or non-violent offence over the next 2 years, is being increasingly deployed. As are drones, which are increasingly relied on by UK policing for finding missing people, tracking criminals, monitoring protests, and enforcing crowd control. Automated facial recognition is also increasingly used, using its algorithmic technology to recognise people from pictures. We also have the Common Platform Programme, which is a digital infrastructure system delivering a dedicated online central hub, allowing organisations including the Courts and Tribunal Service, the Crown Prosecution Service, and the police to share and access relevant information. The Crown Court Digital Case Management System is also used in all Crown Courts across England and Wales, enabling case material to be assessed, prepared, and presented digitally. And finally, courts, not least because of what they went through over COVID, are using cloud video platform to conduct remote hearings. So some of the key benefits of the use of this technology include energy efficiency and effectiveness by leveraging the power of data, technology and innovation. Most police units across the UK can keep pace with changing criminal activity. They can operate more efficiently and effectively and ultimately provide better protection to the communities that they serve. The other benefits include better collaboration through the digital case management system. For example, agencies involved in a case to access and share information about the case in real time, reducing the need for paperwork and improving better communication between the various agencies. And then finally, the better use of resources. In just 7 years, the CPS, the Crown Prosecution Service, has reduced reliance on paper-based processing, and more employees now work from multiple locations across England and Wales on fast and powerful mobile laptops. So the use of technology in courts as well promotes efficiency, participation, and contributes to the reduction of last-minute adjournments. And embracing technology in the criminal justice system can improve efficiency through the provision of these powerful tools to investigate and prosecute crimes and monitor offenders. There are, of course, as ever, some challenges, though, when it comes to using technology in crime, combating investigation and prevention. Overhauling our criminal justice systems and embedding them with newer forms of technology bring their own unique challenges that might detract from the larger objective of modernisation and indeed crime control. These challenges include costs, including both the procurement cost of a technology and the opportunity cost of that technology compared to other use of those resources. There are human associated risks, risks that the human members of these organisations will not be able to adapt or adopt sufficiently to the new technology so it is not put to effective use. And then, of course, there are the hugely challenging issues of privacy versus security. Without sufficient safeguards, supervision and caution, advanced technologies may well have a limiting effect on a range of human rights, undermine the fairness of trial, weaken the rule of law, and ultimately weaken the confidence of citizens in their criminal justice agencies. So just in conclusion, what are some of the lessons that we might draw from the UK's experience for South Africa's criminal justice agencies? I would start with the importance of developing institutional foundations and organisational support for the implementation of technology across the criminal justice system. It is also vital, I think, to develop digital strategies which incorporate aspects of technology and AI for the various criminal justice agents such as law enforcement and the prosecution agencies. And we also need to ensure the establishment of a centralised digital database system for case management for prosecution authority. I also think that continuously working with civil society institutions in ensuring independent monitoring and accountability and mediating the shifting relationships between the justice system and the public has been successful in the UK in terms of maintaining that confidence and the engagement between citizens and the criminal justice system. And I think there are some lessons that we can bring to the conversations here. And then finally, when it comes to the procurement of technology, it's hard, of course, to overstate the importance of adopting plans for long-term, more than 5 years, I would suggest, and budgeting for any and all overheads accordingly. So in conclusion, we know that the technology landscape is changing at an unprecedented rate, and it does not discriminate between citizens, the police, and criminals. And as the Minister just said, sometimes the criminals are less bound than we are by some of our frameworks, some of our laws, some of our norms, and they are using these technologies against us, including in new forms of crime. So it's difficult to foresee exactly how the next decade of policing will unfold and how the next decade of the functioning of our criminal justice systems will unfold. I do believe there is the possibility to see how digital trends, behaviours around data and new technologies will change the nature and volume of demand, and this will affect and impact our ability to respond, which is why it is simply so important for the criminal justice system to remain up to date on new developments in technology. And I would end where I started, which is that the UK remains a fully committed partner in supporting South Africa's criminal justice system and all of its agencies, and all of you, in supporting South Africa's ambitions of achieving a modern, efficient, fair and transformed criminal justice system, and the UK will be your partner in doing so. Thank you very much indeed.
Thank you very much, High Commissioner, for such an presentation. In fact, next week, the Ministers of Justice of the Commonwealth will be meeting in Tanzania and under the broad theme of the use of technology. So I think this intervention is very timely. I will, ladies and gentlemen, complete our panel by inviting the Minister for Justice and Correctional Services to give a high-level observation of the panel's inputs and assessment on the 7-point plan implementation. Minister.
Yeah, no, thank you very much, DG. Offline, I was saying to the DG, but I've said everything. And he insisted that I must come back. So I will just focus on the issues that the High Commissioner was speaking to now. The Cabinet in South Africa in 2008 adopted an integrated justice system, which aimed to enhance the efficiency and the effectiveness of the justice administration, with this main focus and anchoring the digitization of the criminal justice system as a key component of this modernization strategy. The road that we have traveled since then, 2008, has been trial and error from all the departments, from Home Affairs, South African Police, Justice, NPA, and Correctional Services, and the entire court system. We have come a long way to integrate and modernize these platforms. I believe a foundation has been laid. With more enhanced coordination, this integration can become a reality that can be felt in the fight against crime in our country. And I believe that this process of the review of the Criminal Procedure Act will further anchor and enhance this transformative journey of the justice system in terms of its digitization, its integration, for its effective use. This was more pronounced during the COVID-19 period, where courts had to postpone a number of cases because during that period it was impossible to run a trial. The only courts that at least could still function were the motion court procedures under the Civil Procedure Act. But even there, they could not really run a civil trial. With the criminal procedure side on the criminal cases, trials could not be run because we still need to modernize that law to recognize some of the running of trial cases, maybe in digital platforms. I hope that is something that this review could also look into. I know the judges and the magistrate, they want to see the demeanor of the witness in court and so forth. So if you run a criminal trial, how are you going to see this demeanor of the witness? Maybe the High Commissioner could have enlightened us. How do they do it in Britain? Do they do it through artificial intelligence? Wherever the witness is testifying from, it can be able to say the demeanor of this witness is lying or is not lying. Is he speaking the truth or not? How do you factor that into this process? So I hope as we engage with this process of the review of this act, these are some of the developments in technology that we'll have to embrace. But not only embrace and see how we make them function and work for us and bridge the gap, because it has also become very costly for us, the witness fees, the traveling and all that, when someone can testify from wherever they are with the advent of new technologies. So the integration of the system and the modernization of the ICJS project has to find expression in the review of the Criminal Procedure Act, because, as I said, the advent of lots of technologies means that the law sometimes is lagging behind. And technology, as he had shown in Britain, is faster than the development of the law. And this is not a challenge only of the Criminal Procedure Act. And that's why we also have a project with the South African Law Reform Commission to review the civil procedure, which is also having the same challenges we are having, but at least better than the Criminal Procedure Act. And also the repository of information from Home Affairs, Police, the NPA, and the entire court system, from what the Minister Cele was saying. It is the aim of this integration of the ICJS that it must be able, at its well-developed level, for a prosecutor to be able to click at the tip of a button and be able to find the information of the accused, irrespective of whichever court they appear. And it will also be the same for the investigative officer on someone who is looking for bail, to be able to do so through what they call the PVA, Personal Identification Program of the ICJS. And this could also help the Department of Correctional Services in terms of biometric identification, because you may not believe it, but we still have some of the inmates who don't have IDs. And the only way to identify them could be that kind of integration, the PVA and the other technology that we use. One of the challenges you have seen, it was well pronounced in the Thabo Bester matter, with regards to the personal identification of the inmates and the issues that we sometimes find as challenges in the system. So this ICJS program must enable us to close these loopholes, and we are hopeful that also the review of the Act will enable us to look into this, to review some of the sections and the regulations to help us in terms of the personal information and data and the repository of information. So one of the questions I was asked during that period a lot, they were asking me, but don't the courts and the prosecutors make sure that someone has got an ID before they are convicted? It's a question I was asked even at the portfolio committee and so forth. So it is clear that the system has to be tightened, to be strengthened, and to be responsive to the changing conditions in society and the evolution. At least we're able to, Home Affairs were able to end up identifying him on the basis of the fingerprints, and it was confirmed that indeed he is who Home Affairs said he is. But all those are issues that needs to find integration in the system. It must have a relay effect from Home Affairs to the police, to the NPA, to the courts, and to the correctional services. The data must be seamless, it can be shared. But I was hoping also the High Commissioner will also speak about it in how in Britain they developed it. So one of the first, in one of the Commonwealth meetings, I engaged with the minister from Britain, the Minister of Justice, because I was raising it with him that day. Since 2008, we've been working on this ICJS, is the coordination. We are trying our best to integrate and modernize the systems. It looks like you guys have got it right. So he said to me, no, don't think that we did it in a split of a second. It also took us many, many years. It's not a big bang kind of a program or outcome. It takes many years. You will also get developers who will come and sell you heaven and earth, and after 2 years or 2 months, you realize this thing does not work. You need to go and get another one. And so even in the Britain, they have walked that difficult route. But what is key is that with the systems that we are able to develop, proof of concept, be able to get value for our money. which is another challenge that we are encountering. But I believe that is not the challenge of the law, but it's a challenge of also our own systems. That as we develop, modernize, we must be able to get value for our money in terms of the investments that we are making with the developers of this system. So in these few words, DG, that you forced me to say, I hope the program and the review have picked up some things that will be relevant for the bill. Thank you very much.
Thank you very much, Minister. Indeed, I don't regret having convinced you to speak. Your intervention was profound and very helpful as well for this panel. We have come to that time, colleagues, for the dialogue and debate. I want to recognize 5 hands, this side, and this side. The first, okay, I've seen that one at the back. I don't know whether you'll assist us with microphones. Yeah, any other hand? 5. I want to take a first set of 5 hands. Yes, the gentleman here on my left. Can I come to the middle? Here in the middle, the center. Okay, let me move to my right. The lady here in front, you seem to be doubting, are you sure? Yes, the gentleman here in the middle. Anyone at the back? The center again. Okay, to my left, right, the gentleman there. Okay, let's start here on my right, the lady here in front. Okay, they're still getting the microphones.
Thank you, DJ. My name is Nolundi Tia. I'm from the Integrated Justice System. I'm just interested to know from the High Commissioner of the UK. He shared the number of the agencies, the criminal justice system agencies, and the technologies that they use. AI, big data, data analytics. However, my question is, how do they ensure that there is integration between these different agencies? I didn't hear him saying probably there's a certain agency that is responsible for ensuring that integration, for better data integration and for better criminal justice system management. So if he can assist with that,
Okay.
probably from the ICJS, we would learn a thing or two from that. Thank
Okay.
you.
What coordinating mechanism do you have for the multiplicity of agencies that are involved in the integrated justice system? The gentleman in the middle. They are behind you with the microphone.
Morning to everyone. My name is Zweli. I just have to say 2 things. One to the Minister of Police and the other one to the High Commissioner from UK. Firstly, to the Minister, it will take years if you are a coach to coach a team and the team doesn't have quality players. I think the work of SAPS, it must be a calling, not just work. Passing to the High Commissioner of UK, are they aware in UK that the highest crime there is fraud? Most of them committed by people who are having South African passports, but not South African in origin. And again, if UK and South Africa, they are that part. Hello?
No, we can hear you. Proceed, please.
If UK and South Africa are that partner, I remember some years ago, someone did a fraud case there. They arrest and deport, not release back to the community. Why is not happening in South Africa? Thank you.
Okay, there was a hand. Was it this side? Okay, those were the two hands from this side. The gentleman that I first recognized there. Yeah.
Good day. My name is Kotatso Moloto, and I'm the founder and president of Voice It in Action. Thank you to the panel, the ministers, High Commissioner. The reality is that we are fighting a monster that needs all parties to play. It's going to take years for us to actually be in a position to make a difference, but are we preparing for it? Technology is a key component, but do we have young people who are given an opportunity to participate in developing prototype solutions that could be tested and put into government to ensure that we achieve what we are looking for? We need to make sure that we are meeting the needs by allowing the community, especially the youth, a platform. There's a lot that can be achieved, but if we are not given that platform or the resources, then we will have a long way to go. Some of these things are not easy, they will never be, but it requires a willingness from government, from our leaders, to enable an environment that enables growth and development. If we do not do that, we will be coming back a few years later, coming to talk about the potential of technology, but we wouldn't have implemented anything. It's high time that we innovate. It's high time that we challenge South Africans to give us some of these solutions. And I do appreciate and thank the opportunity to speak, but ministers, I believe we can do more. And beyond this conversation, can we actually challenge the youth to be a part of these programs and to give them the technology and to develop technology? Because I mean, when you think about technology and where it comes from, it's developed especially now by the young minds. They are the ones that are on TikTok, social media platforms of all ages, etc. You can name them. They know how they work. They can tell you about the algorithms, but we are not utilizing them to come up with these solutions. So going forward, I believe that we need to give the youth an opportunity and a platform to learn and to use what they understand and love, which is technology, to help in fighting against crime. You might be surprised that some of these young people know exactly what's happening, but because they're not given a platform, they sit back. Somebody asked, and they said something very critical. They were like, Kotatso, why should I do anything for South Africa when South Africa does absolutely nothing for me as a young person? I walk next door, I go to my neighbor, I ask for something, I go to government, I ask for something, and I come back empty-handed. It's high time government opens more opportunities for the youth so we can make a difference, so we can have more patriotic South Africans who will take a stand. When they see crime, they will act against it. But if we don't empower them, nothing will happen. So it's high time we ensure that there is innovation and that you bring young people to the forefront and you give them a platform. There are so many ways in which we can drive change. There are so many opportunities that can be developed. But I'm challenging the ministers and I'm willing to participate, and I do believe that there are many other young people who are willing to do so. Let's create a platform for the youth to deal with these challenges, and I believe we will have a lot of solutions. Again, I am Kotatso Moloto, the founder and president of Voice It in Action. Thank you again for this opportunity.
Thank you very much. There was a gentleman behind him there.
Ms. Hagai Makatu from Justice College. My question is to the High Commissioner. I'm quite interested in the attitude of the British government on the containment of artificial intelligence. You know, this intelligence is always ahead. Have you ever thought of controlling the speed of artificial intelligence by deciding what should be designed in terms of machines so that you are able to catch up with the speed. Because otherwise, if you look at what the Chinese do, is they do not allow things like deep fakes from destroying the good that artificial intelligence brings to mankind. So from the British government, as one of the leaders of the world, what is your attitude in controlling that artificial intelligence from designing the machines that end up destroying the lives of our people? Thank you.
Thank you very much. The last stand was here. There was a gentleman here. There he is. Okay, give him the microphone.
Thank you very much, Program Director. My name is Comrade Mpuru. I am from Department of Defense, but then at the same time, I am in the house shop steward at the branch level. In most of the time, I regard myself as a comrade, but immediately when you speak of word comrade, people think that word comrade means someone who is an instigator and so forth. But when you consult your dictionaries, it will tell you that the comrade is someone who is humble, who is advocating for peace and harmony.
Let's see the humble part of the comrade.
I'm concerned, pardon me for my loud voice, I adopted it, I don't know, they say from the genes. So I'm concerned with Section 35 of the Constitution of the Republic of South Africa. And I want to raise this question directly to the Honorable Minister of South African Police Service. There is this thing that is called petty crimes, theft, house robberies. You realize that one day in the middle of the night, advocate, around 2 o'clock, 3 o'clock in the morning, you hear the sounds in your house property. When you open your doors, you realize that no, man, there is a thug who's trying to steal your tire wheel. Mind you, sometimes you are in a position whereby you just brought a brand new wheel tires. Someone is there who's trying to steal your wheels. And unfortunately, our laws or our Criminal Law Procedure Act doesn't allow you to do anything to that particular culprit. What you must do, you must call the police. That no, there's someone here who's trying to rob me of my wheel tires or whatever in your household. Now, the negative part of that is the fact that you do that, you follow the procedure according to the Constitution and the Criminal Procedure Act. You report it accordingly to the police without harming that particular thug. But then, all of a sudden, after 2 weeks or so, you see the same very particular person roaming along the street. He is greeting you to say, Comrade Mpuru, you thought that I was going to be arrested for more than 2 months, 3 months. Here I'm out again. What is it that you're going to tell me? Now, I wanted us as fellow comrades and members of South Africa, particularly in the field of people who are dealing with the law of criminal procedure, to have a review, a relook on that particular Section 35, to look at it in the manner in which when you find someone in your property doing whatever that is not just, or someone trying to rob you or even kill you, what is it that must happen? Because it's very painful. Sometimes you find that no, when you try to approach him, he's even opening a knife to say, no, come. You cannot do me nothing. You are armless, you are just nothing. I'm here, I'm going to take these wheels. You cannot do nothing about it. Knowing that, no, when you report him to the police, after 1 week or 2 weeks, he's out. Now, I want us to have a review on that Section 35 of the Constitution, in terms of which when you find someone in your yard doing whatever that is it that they want to do, what do we do about that? Do we say we call the police come and arrest, and that particular person is out on bail or is out from prison permanently? So just 1 day or 2 days, such a person is out. So I want us to have a review, because I think for me, Section 35 is too lenient to deal with the petty crimes. Thank you, Honorable Advocate. I will pose it from there.
Thank you very much, comrade, for that question. Let me check before I come back to the panel, maybe with the supporting panel members, Advocate Batoi, National Commissioner Masimula, National Commissioner Tubachale. Any of those questions that you want to take before I return back to the high table? National Commissioner Masimula.
Thank you very much, Program Director Advocate Mashabani, the ministers present here today, the judges and DGs and everybody present. Maybe I will start with the first, the last question of the comrade there at the back. He says, it's a petty crime. Housebreaking and house robbery is a petty crime. It is not. It's a very serious crime. However, yes, as a resident, when that happens, you have to either, do a citizen's arrest if you can. If you can't, you call police. And of course, we'll do our work, arrest the person, take him detain him, and then he will appear in court. And of course, if he gets bail, there's nothing much that police can do. Remember, everybody is entitled, everybody who's arrested is entitled to apply for bail, is entitled to be considered for bail. That is not within the police. It is unfortunate that whenever people, after they have been arrested, when they are on the street, because they are arrested by police, then it is the police, according to the society, it is the police that have released them. So it is just unfortunate that we carry that brand, but at the end of the day, it is not the police. The person have got bail, as the minister said earlier, people do get repeated bail for one and the same crime, and there isn't much. There is an example of a case of Northern Cape where it was late last year, where a young girl was raped by somebody not far from the family. Person was arrested, sentenced, and then he got parole. And then every time this person walked that street, he talked to the child cries. And it's a very situation that nobody can tolerate. But it took time until we intervened as police and took the person back to correctional services, and they canceled the parole, and the person has served again. So it's unfortunate that, yes, people get released on repeated bail, and we must carry on continuing having to arrest them again for the same crime, which definitely, yes, we agree that we think there is a need for review in that regard. And also, I think it was mentioned earlier also, where people get arrested, bail is opposed, bail is denied. But when there is appeal bail, it is always said that the accused have brought new facts. Our question is now, why wouldn't the state also be allowed to listen to those new facts so that it can be opposed? So it's unfortunate that normally the investigating officer is not called when there are new facts. And normally the person will be given bail at that level, and only to find that once you go back, it deals with whoever, especially on serious and violent crimes. As you are aware that, yes, people arrested, they're entitled to copies of the docket and so on. So what they do, especially in serious and violent crime, they will ask the docket, go through it, of course, we suppose with their legal advisors or their attorneys, identify which are crucial witnesses that are going to send this person to jail. And thereafter, those specific witnesses are eliminated all of them get killed. Now, we can't have the whole society, whoever is a witness to a case must go to witness protection. It's too many to go there. So maybe we should review this issue of should this availability of the contents of the docket, it needs to be managed how? Because most serious cases, especially were murders, once people get out of bail, they eliminate all witnesses, and then the day they walk free. Thank you very much.
Thank you very much, National Commissioner. I was in a funeral on Saturday in Mpumalanga, a highly charged funeral because we were burying a victim of GBF who was killed by a lover. So the community was highly charged. And I tell the community that, look, where you hear where this perpetrator is, alert us and the police. They nearly stoned me. I said, no, we can't hand him over to you. When you hear about where this person is, you must tell us, the community, go and take care of him. But my colleague from your service, National Commissioner Masimol, was talking about what the minister was raising here, that you see, Tina, as police, siyababamba labantu. But where they get released, we don't know. Maybe the DG of Justice will explain. And, and then the police were heroes because they are known to arrest, but the problem seemed to be somewhere else. I don't know if National Director, you want to make an intervention. There's a request that there's a camera, we must be looking at the camera. So unfortunately, you may have to turn your back on us as the panel here.
Oh, okay.
Oh, you are here now, so there's no need for, yeah, okay.
No,
Proceed.
thank you, Gigi. I think, given the comments on the bail issue, I think we all know that there's a very specific reason that bail is granted, you know, or not granted. If you're a flight risk or if you're going to interfere with investigations and we need to prove that, then of course the courts will either grant bail or refuse bail. So, you know, the problem is not with bail, I suppose. It's the way we explain what bail is actually used for. And it's important that the communities understand that. And if there's good reason for people to be kept in custody, then I think it's important that, and it's not just important, we work with investigating officers and we oppose bail in appropriate circumstances. And so I think it's really important. And so on the one hand, we have the urge for people to be released, to be kept in custody. And then we're going to have our minister and the Commissioner of Correctional Services who say that we are overcrowded, we have an awaiting trial population. That's, you know, so there's all of these issues that need to be considered. But I think I just want to take the opportunity to make one or two comments, because I don't think I'll be here for much of this, and to say that this, you know, this is really so opportune that we are dealing with the review of the Criminal Procedure Act at a time when, let's not forget the context, we are facing extremely high levels of crime in this country. And I think this, in as much as, of course, we must, our constitution is sacrosanct and we've got to, you know, have regard for all of these very important ideals. We've got to understand that we are in a crime crisis in this country. And how do you strike the balance between trying to bring down the crime rates and actually ensuring that people's rights are respected? So I think that this is hugely opportune, given that it's almost 50 years since the Criminal Procedure Act in 1997. And so much has changed in terms of the dynamics of the country, in terms of, you know, the type of crime types that we're dealing with. Technology has advanced, so I really appreciate that the department is doing this at this time. And I think we really need to understand that, you know, when democracy happened in this country and institutions and legal frameworks were put in place, it was a very, very different time and context. And things have changed, and I think perhaps there were some, what we might call, design flaws. And we really need to look at these issues, not just in terms of the Criminal Procedure Act, but the Minister also, the Minister of Police, talked about witness protection. We've got to deal with that. And if we're looking at an effective criminal justice system, we've got to look across the entire system. And so if you look at the National Prosecuting Authority, there are huge design flaws there. And so we must firstly appreciate the Minister for the fact that the NPA Act is now going through Parliament with certain specific changes relating to the ID, but for the commitment of the Minister as well as the DG to ensure that in order to ensure an effective NPA, that by January 2025, there will be another amendment to the NPA Act that will deal with critical issues like the operational and financial independence of the NPA, like the appointment processes of a national director, to ensure that we make the NPA, we protect it from future capture. And so these are important processes in the criminal justice system. And so we talk about the police, we talk about the NPA, but rule of law doesn't end there. It goes to the judiciary. And when police make arrests, prosecutors prosecute, you've got to make sure that to have confidence in the rule of law, the cases move quickly through the system. So how we can, in this process, try to address issues of Stalingrad tactics that really make it very, very difficult for cases to move fast. And so when we are asked very often, you know, how many convictions have you had with regard to serious corruption cases? There are many cases enrolled, but what happens in the system that takes so long for cases to be finalized? And I think these are issues that we need to look at in terms of case management, in terms of you know, the technology. So there's a lot of issues that need to be dealt with in order to ensure that the system that the people don't have much confidence in. I'm really hoping that this process is going to help to build some of that confidence. Thank you.
Okay, thank you very much, NTPP. Is Mr. Munyai here? I wanted him to assist us just on the, okay, when I take the National Commissioner for Correctional Services to assist us on the question of the role of the youth in innovation and development of applications in the integrated criminal justice, or someone from CETA if they are here. National Commissioner Tubakhali. Here in front. And also if there's a constitutional lawyer who can defend Section 35.
Thank you, Program Director. We are at the end of the value chain as the correctional system. And as usual, when discussions about the efficiency and the effectiveness of the criminal justice system are raging, we are hardly mentioned. And I want to thank the chairperson of the JCPS cluster, the Minister of Police, and also the Minister of Justice and Correctional Services for mentioning the role that the correctional system plays in the criminal justice system. Now, for us, the conference also comes at an opportune moment because we are reviewing the correctional system. Of course, from a policy and legislative perspective, legislation perspective, but also from the perspective of the operations of the system, the kind of results we get from what the system is enjoined to do by the Constitution. We have a correctional system. Before the advent of democracy and before our Constitution and the Bill of Rights were passed, we had what was called the prison system. Now, the correctional system is steeped in practicing and observing human rights, and the Correctional Services Act is instructive in this regard. Not even regulations, the Act itself prescribes in a very detailed manner how we need to observe human rights and how we need to comply and observe constitutional provisions. But the transformation from prison system to a correctional system happened in a legislative and policy manner, and the effect was actually what we term demilitarization of prisons to correctional centers. Now, you have correctional centers that are more concerned about rehabilitation, correctional programs, habitable and humane accommodation of offenders. So this is us ensuring that we do not undermine the Constitution of South Africa. Now, in the process, as we moved from a prison system to a correctional system, and I've indicated that it happened in a legislative and policy manner. I'm actually indicating that there are transformation processes that were supposed to take place that deal with the DNA of the system that did not take place. It's a legislated and policy environment that you flip and comply to. Now, in the process, the capacity of the correctional system to contribute to crime prevention within the correctional facilities, the capacity of the correctional system to deal with security threats and risks that present themselves, of course, with the changes that happened over time, the issue of technology and the fact that the environment is no longer the same as the NDPP has just mentioned. That capacity continued to be eroded. And on the other hand, it has already been mentioned, we are facing unprecedented levels of overcrowding, a perennial problem that continues to deep sit in correctional facilities, dwindling of resources. We practically do not have an increase of correctional facilities in South Africa. Even if we build one, we build it after 10 years, the capacity of less than 3,000. We are currently at an occupation rate of 148%. Basically, we are 48% overcrowded, and the numbers are increasing. And I really am just amplifying what the panel was presenting. So what are the results? The results are basically a rise in security incidents, escapes, incidents like the one of Thabo Bester. We are currently experiencing a continuous sharp consolidation of gangs and criminal rings in correctional settings. And of course, on the other hand, if you look at the health conditions, overcrowding brings an increasing risk of diseases. So the conference for us is relevant in the sense that it will give us a footing into the review of the correctional system, the review of correctional settings. But yes, we also have to look at how do we balance the human rights culture and the security risks that are there that continue to prevail in correctional settings. And maybe we also need to rethink whether a correctional system is not a security system. Because at the moment, a correctional system is not regarded as a security system. It's regarded as a rehabilitation and correction system. Hence, you do not have the capacity that I have indicated to prevent crime from happening in correctional settings. Let me stop there, Program Director. I thought I must just share a bit. Thank you for that opportunity.
Thank you very much. Mkoni, I know that once you are a judge for life, but you are a little bit freed from the monitoring of the Chief Justice. There are things that President Musi may not say, but you have the liberty to say you.
Yeah. I prefer to listen than to say anything, because that is very important and perhaps is part of the role that have been imposed on us. I'm getting to booklet number 2 now and I'm taking notes, so I do not want to be interrupted, and I'm sure colleagues will take that in good spirit, and I'm serious about it because there's so much that has been said, and one needs to properly ponder on the issues which have been raised by people who are here. Thank you so much.
Thank you very much. DM, are you friendly with Section 35?
What was the issue with Section 35?
The problem of Section 35 giving a lot of rights. That people break into people's houses and...
Look, I was looking at it. I mean, I think the issue is obviously that a person is innocent until proven guilty. So I always remember a case from KwaZulu-Natal, from Bulwer. Some of you may have heard this before. A teacher knocks a learner's head, hits a learner's head with her knuckles because she's annoyed with him. And that's the incident. And then the boy goes home and he complains that he's got a headache. He tells the story, and later that night he dies. And the community are up in arms against this teacher. It's a woman teacher. So she gets arrested. They're protesting at the court. She mustn't get bail. And I think initially she doesn't get bail for her own protection because she might have been lynched or something might have happened to her. Eventually she gets bail. Eventually the charges against her are withdrawn. Because when the post-mortem results came in, the child died of meningitis. It was just a coincidence that it happened at the same time. So I think the issue and what's important with Section 35 is it's arrested, detained, and accused persons. It's not people who've been found guilty. And it's the issue of the right to remain silent, which is key in our procedure. I mean, in our system and internationally. The right not to be compelled to make a confession, to be brought before a court within 48 hours, obviously provision for weekends. At the first appearance, to be charged or to be informed of the reasons for the detention. And then you've got if you're detained, the right to be informed of the reason you're being detained, to consult with a legal practitioner, to have a legal practitioner assigned at state expense, to challenge the lawfulness of your detention, and the conditions of the detention must be consistent with human dignity, etc. And you can communicate with your spouse or partner next of kin. So that's for detained people. And then accused persons, a bit more, informed of the charge, given time to prepare. You have a right to a public trial, to have that trial begin and conclude without reasonable delay, to be present when you're tried, to choose and be represented by a legal practitioner, to be presumed innocent, to remain silent and not to testify, to adduce and challenge evidence, to be not to be compelled to give self-incriminating evidence, tried in a language, this is quite topical, that the accused understands, not your home language, but one that the accused understands. Not to be convicted for something that wasn't an offense, not to be tried when you were previously, for an offense that you were previously acquitted of. So those are broadly the rights. I'm not sure then which right there's a problem with. Remember also our history. We come from a background of detention without trial. You could just be locked up. Okay, part of it was state of emergency, but before that, before the state of emergency, it was the Internal Security Act. The National Party government tried to prevent the courts from checking as to whether, or for people challenging their detention in court. So we've got to remember that history. And I think the issue is if you read Section 35, those are the rights for the accused people. It's not about people who've been found guilty. What are the rights there that people here might have a problem with? So I don't know if that responds sufficiently. Maybe just also to say with Section 49 of the Criminal Procedure Act, which Minister Cele had raised, that is about the use of force in effecting arrest. It's not about the right to self-defense, which police would have. And it's when you can use, and it was changed twice since to the original section. But we've also got to be careful we don't end up like America, where it would seem that if you're, that a large number of black people get killed on arrest when they're actually innocent. So we've got to be looking at a balancing act. But again, going back to 35, I've read out the sections. Which of those rights is a problem? Thanks. The NDPP wants to add.
Just 1 minute. I think, a right to a fair trial is really important for the prosecution. But just listening to the DM who asked any particular right, and when the team's looking at this as we move forward, for example, the right to remain silent, it's hugely important, but there's no right that is completely unlimited. So under what circumstances, would it be justified for certain rights to be limited in certain ways? Because it ensures the interests of justice, for example. So these are really important issues that, hopefully will be interrogated here, and that moving forward we can look at, more closely in amendment processes. Thank you.
Okay. So if I can just add one quick thing on the right to remain silent, just while the High Commissioner is here. I think during the height of the IRA struggles or violence or whatever, the Northern Ireland government tried to limit the right to remain silent. And as far as I recall, it didn't work particularly well. I'm not sure if the High Commissioner has any knowledge on that, probably not, because it's a niche area. But there have been attempts by democratic governments to reduce the right to remain silent, and they haven't really had the effect desired. Thanks.
Thank you. Thank you very much, DM. I'll return to the panel. High Commissioner, there was a question raised with you.
Thank you very much indeed. Deputy Minister, I am not expert on that niche area, but I would agree with the basic premise that we have tried various times to limit rights and it doesn't always work, or it has unintended consequences. I think there were 3 quick questions levelled in my direction. One from the lady over on the right, I think, was broadly about how do we ensure proper integration of the technologies across our criminal justice agencies. I think that's a hugely important topic. Not just in the criminal justice systems, across the bureaucracy in my own government. The times you will find that our computer systems don't talk to each other because they haven't had the right conversation at the beginning of the processes. But I think it's a known, so I think it is something that can be addressed both through procurement. I don't know if it's the same here, but certainly every department in the UK, most departments at least now, will have a chief technology officer. They all talk to each other. They should all be planning the future of our systems, the future of our processes, the future of our operational priorities. And the other comment I would just offer, rather obvious, is having a clear sense of what is the shared outcome. I think across the criminal justice agencies, what we want to see is technology making processes more efficient, more effective, ideally more resource efficient, apart from anything else, and making sure that a case can move smoothly all the way through the system from the beginning all the way through to the end. And in order to do that, using things like common databases, I think has got to be the way to go. The second question, I think, for me was the topic of the prevalence of fraud in the UK, including those who are not from South Africa but have got hold of South African documents. Again, in the privacy of this room, one of the most common topics I find myself talking about here is the fact that we have a visa regime that was imposed, of course, in 2008 because of precisely that problem, that there was a concern that people were getting hold of South African passports and then getting into the UK. This is something we have a very, very good dialogue with the Department for Home Affairs about. It is something I know that the Department for Home Affairs works extremely hard to ensure that people who are trying to leave South Africa with fraudulent documents get stopped at the border, and they do so with some success. We also have a regular dialogue at high level with, as I say, colleagues in DHA around how we can handle the issue of returns of people who actually are South African and have ended up in the UK, either overstaying a visa, so that's a fundamentally important part of our discussion. And there was also, I think, a second half to that question, which is why is more not being done about this in South Africa, which I will defer to my South African ministerial colleagues to address, because I would not want to speak for them. And then the third question for me was around AI and the challenge of how we exploit AI without AI, I'm going to paraphrase the question slightly, without AI being used against us. And should we therefore control more directly the creation of AI, the operation of AI within our economy? The UK in November last year, partly in direct response to this challenge, chaired what they called, or we call, the AI Safety Summit, with a range of countries, about 25 countries, including the US, including China, a few from Africa, a number from Europe, etc. And it was precisely to talk about that problem. How do we get the balance right between regulation of the creation of AI, regulation of the operation of what's called frontier AI, to understand the risks and to really establish what is the appropriate level of regulation? We, of course, all believe, certainly in the UK, and I think I feel this here in South Africa, there's a very passionate commitment to innovation. There's a very passionate commitment to allowing people to experiment. I was giving a talk yesterday at the Johannesburg Business School specifically about how we can work with both South Africa and Kenya and others about AI, innovation more broadly, but we did touch on AI and its transformative power for economies such as South Africa. One thing that we believe in very passionately, actually across the board, is having the right conversation between the public sector, the private sector and the academic sector, so that we set rules and regulations and policies that are appropriate, that are, again, I think we have a right as governments, we have an obligation as governments to defend our citizens, but how do we get that balance right? And then the final thing just to mention is that one thing we announced at the AI Safety Summit in November last year was a partnership with Canada, where we are looking specifically about AI for development in Africa. And that is a conversation that we are now building out with key stakeholders here, as well as across the continent. Thank you very much.
Thank you very much, High Commissioner. Minister Tele.
Okay.
No, thanks. Ulamula, who comes from Bushbuck Ridge, and myself, who come from Umzumbe. I was just saying to him, this is a cool room, cool people. If I take you to under the tree, when the village has been collected, and you say these things of remain silent, you say it here. Maybe our scope of consultation is too restricted and too educated. You know, people, they ask this question, remain innocent until proven guilty. When we saw you shooting somebody, we saw you, we found the gun, but you are innocent. Maybe new form of consultation, bringing on board the broader communities. I know that Parliament does it and all that. In a restricted way, they go there, they have some tea, they have some few representatives and all. They don't go under the tree, with village, in Makaya, and then they sit there and they allow people to talk. By the way, it's one very fulfilling feeling to be insulted by the people under the tree, telling them pure understanding of what they want to say to you. So this question of restricted, calculated, of consultation, and you say you have consulted, we'll have to find a broader way some other time. Zoel, I heard much about what you did not say. I heard what you said, but what was broader is what you did not say. You say work of the police should be the calling, not work. I heard you very well. You should la mapoisa kona la. Ayasebenza is not a calling. I agree with you, but that should be for all of us. It's not only the police that should have a calling. Everybody that provide the service should be a calling, not police only, including abefundisi. These magistrates and judges will tell you how many cases of pastors are in front of them as we speak. Abefundisi. So you find amaphoyisa nebhadi nje. Because then the cold front of everybody blames them for things that they did not do. But when they do their work, there is very little that I always make a call. Slice the police for bad things they do. But remember that they have a shoulder to pat when they do well. It's human nature. Everybody wants to be reminded that you have done well. You know, there are many police who are doing well, including very high sophistication within that organization. I'm both the victim of police and the perpetrator because I'm a police now. I work with them. There is so much excellence within the police. The only problem, when it comes to excellence, people don't want to talk about it because they want to remain and leave police as if it's a bad bunch of people. There's been a big thing here, Advocate Pato will know, of something called DNA. Many of you would know. There was a hell about the DNA, hell, with a 251,000 backlog. Today, that backlog is zero. Completely zero. So much work has been put on it, including employing 150 BSc graduates in the police. 150, they are there. They're in those laboratories. They're in those forensics. If you have read your report last week by the independent board, they say they've never seen such an old machinery when it comes to the laboratories of the South African Police Service. That's not me saying. It's an independent board that is chaired by an advocate saying this is the best that police are doing at the present moment. But unfortunately, it doesn't find the pronouncement. It's not pronounced. It's only pronounced when there is a backlog. When there is zero, it's not pronounced. I don't know whether that is deliberate or people forget when things have been fixed. But that's that. One of the judges spoke about one captain, he's a captain now, was a warrant officer, who did Mrs. Tole case. Mrs. Tole is a former cop, is a police. That will ensure the family, or is to insure somebody, to if he dies, get the money. This aunt was insuring all relatives and papa them and get all the money. And this captain, this warrant officer, was a sergeant then, cracked that case to such, when the judge gave the judgment, he said, I never knew that there is such an excellence within the South African police. I never knew. The good work that he did. So, there are bad police as well, terrible, like bad teachers who impregnate school kids. Like bad all of us, like bad parents who allow children, a 13-year-old, to carry the gun and go and shoot the principal at school. That's a bad father. We're all bad in all other categories as human beings. And the sooner we accept that, is better for correction on ours. You can't have a father who allowed a 13-year-old to get a gun and go and shoot the principal at school. And you don't tell me that that's a bad father. So across the board, there are bad human beings. Across the board, there are beautiful and good-hearted human beings. I always say to Lamula. Lamula is 40% overpopulated, 44 now, overpopulated in correctional. Not a single prisoner that goes in prison on Toi Toi. We arrest them. For the judges and magistrates to give that person a life sentence, which means a good job has been done in the investigation. And indeed, there will be bad police that they cause the withdrawals and all that. So, when you deal with the calling should be across the board, but you must also know that there are pockets of excellence and there are bad people across the board of life. The question of technology, I fully agree with that. But somebody asked a very interesting question. But that question was also asked by Minister Lamula as we're talking here, that we might find that the laws we make, they fall behind the technology. The technology is much ahead. But technology does help a lot. We are using it. We have a big contingent now of the drone pilots within the South African police. I've just seen them. They're quite young. They are pilots of this thing. I got so much interested to look at the drone policing. When you go to Deep Slot, that's my favorite place. When you go to Deep Slot and the place that you can't walk, your drone tells you they are the people walking at 2 o'clock in the morning. I really know that drones can be used to send people to go and sleep. And the drone will come, put the light, everybody runs and gets in the house and all that. So there is a drone policing which is science, but there is also what you call a short spot. National Commission, they're beginning to expand that. A short spot is a technology that tells you in next 30 to 60 seconds where was the bullet shot, where was the gun used. We're putting those things in different places to be able to respond. So technology really is a way to go to help all of us. And I think I fully agree with putting a lot of technology. Sitting down on, is it 35, JJ, yeah? No, 35, yeah. Sitting together on both 35 and 49. I agree with you, maybe, that there was so much on the background where we come from when the laws and constitution were made. But it gave so much loopholes for criminals. You know, we're policing on two worlds, completely different worlds. We're policing on the world where communities, they must rise for their rights, they must fight for potholes, they must fight for not having water, they must fight for fees must fall, and police must police those group of people with a full understanding that they have all the rights to do that. That's why Judge Falam would say, you go there and train your public order policing on understanding that these people have the right to do so. And you police them as such. As you police them, also protect them as they protest. Protect them. That's the world we are policing. We are policing a second world. For people that sit down, they plan. Their planning and plotting also include the elimination of life if that life comes in front of their work. When criminals of crime of CIT, cashinas, plan, they don't buy broomsticks. They don't buy feather dust. They buy real stuff. That real stuff is to eliminate whoever. So we are not going to approach that policing as if you are approaching fees must fall. So those that face that, those guys who go hijack the car, for a cash heist. They shoot that person as they hijack the car. They kill that person. They go and break in your house to steal your firearm so that they are armed the day they go for cash heist. They cross the border to get some explosives. They plan, they sit together. And you expect police to respond as if that is fees must fall. The law must understand that those days come. When you are approached and you say, we are preparing for crime, they don't answer those guys, they shoot. So, it's a last request. Understand that we are policing the very bad world and the world that you respect, because protesting, you are respecting the Constitution because the Constitution allows you to do so. But it also gives you some restriction. Unarmed, no violence and all that. But as that Section 49, JJ, must not forget, whatever it is, whatever section it will be, must not forget that criminals, when they plan cash heist, when they plan bank robbery, when they plan robbery, when they plan raiding the factory, when they plan stopping the truck that is full of TVs and all that, they don't carry broomsticks, they don't carry feather dust. Allow us to use the hard stuff as they use the hard stuff and protect us. Thank you.
Minister Lamola, if you can round up for us.
I think we are now at the core of the conference, because we are now grappling with what we wanted the South African Law Reform Commission to help us grapple with. Because since 1994, we have never had this kind of a review of the Criminal Procedure Act. How do you police, enforce the law, and also ensure that there is a fair trial in a constitutional democracy? Because in the past we were in a parliamentary sovereignty where there was no Section 35. It was by decree of the Minister of Justice. You know, as I was coming this side, I see my colleagues and the debate of the ANC NEC on the 30th year of our constitutional democracy. They are beginning to put some pamphlets showing that this area is for white people. If you transgress this law, you are going to get 10 lunches and all those kind of things. And down there it's written by decree of the Minister of Justice. So that was the apartheid policing system under that context. We are now in the context of a constitutional democracy. How should it be, this policy? And Section 35 says this is how the rights must be enforced and it must be protected. And the NDPP raises that we are now in the context of a violent society and high crime rate. This conference will help us balance this. These rights that we have to have a trial, which is still within Section 35, it's a fair trial, and it is done within the context of the Constitution. Because it can also be self-defeating if it is not done within the context of that Section 35. Or the Criminal Procedure Act that is compatible, or it is constitutionally valid. So we are expecting that at the end of this conference, you will help us come up with a bill that will take into cognizance all these factors that have been raised now and the ones that will be raised as we move forward. These are issues that ourselves grapple with on a day-to-day basis. So when you are here in numbers, you are helping us to find that balancing act, how we navigate in this constitutional period. That is the only thing I wanted to say, DG. I won't comment much on the specifics. I believe that the conference will continue to help us to find that solution. Thank you.
Thank you very much, Minister. I was tempted, Dilize Ntawa, to ask you to raise that question that you normally raise, but I can summarize it for you. That's still Section 35, that Deputy Minister Olomisa, when he does his royal duties, the people ask him, this criminal commits crime, you arrest him, he gets to court, you then come back and give him a government lawyer to represent him. So this is part of the contradictions that the conference should look at, which is in Section 35 as well. That you say you are fighting crime, you arrest, and you take a lawyer and say, represent this person not to be found guilty. So those are some of the things that the conference will continue dealing with. We are doing well in terms of time, and that. Okay, all right. We are doing well in terms of time, and for the good behavior and to reward the humility of the comrade. It's not always that on a daily basis you come across a humble comrade. I will at least give us a break 30 minutes before time. And I'm told that lunch will be served at the room at the back of so that will be to the east, if I'm correct that this is the north. And if we can return back here at, I think an hour should be enough to have lunch. Maybe if we do 75 minutes, but we make the lunch to be a working lunch. So I want to appeal that magistrates, judges, and lawyers must not sit together. If we can spread in the different tables and continue with the discussion, the use of technology, Section 35, the bail issue, the right to remain silent. When we come back, I'm going to dedicate about 30 minutes to get rapporteur. Senior table, appoint a rapporteur. We'll come back and report on what was the discussion. I've discovered in conferences that the real conference doesn't happen here. It happens during lunch. So that's why I want to harvest the ideas from lunch by making sure that every table has a rapporteur who will come back and give us a report here. So let's come back at 13:45. That's 1:45. Thank you very much. I want to thank the panel and the High Commissioner as well. Let's give them a round of applause for the excellent discussion. Thank you very much. I'll give 3 or 4 rapporteurs 3 minutes each to quickly give us a report from the working lunch discussions. Any volunteer? There is a volunteer there at the back on my right. May you please come and give us a quick, yes please, yourself, yes. Any other volunteer? I just need 3 to 4 rapporteurs to come for 3 minutes and give us a feedback of the table discussions during lunch. Okay. No, there was Amanda there in our table that from LSSA. Amanda from that table, the high table of the ministers. Okay, you have the floor. 3 minutes.
Good afternoon, everyone. All protocol observed. My name is Sabelo Nubangule. I practice in the space of the criminal justice system. The observation that we have made was the level of generalization insofar as the issues are concerned. And we hope that as the time goes on, we might be able to zoom into the specific issues and outline insofar as the law, the legislation is concerned specifically, because the system issues are issues that can be tackled and overcome. Because the problem with the generalization is that there might be panic buttons that have been pushed, and we've got reference to 2 pieces of legislation that have been introduced specifically because of rising crime levels. Those who are practicing in the space will know that I'm referring to the Criminal Law Amendment Act of 1997 that was meant to respond to the crime. And the jury is out as to whether or not it has adequately responded to what it was supposed to achieve. Your so-called Minimum Sentences Act. And the second piece of legislation, which is found in the Criminal Procedure Act, is the Section 286 A of, is it A, I'm not sure, of the Criminal Procedure Act, where judicial officers are supposed to follow a process to declare people dangerous criminals. And there was a commission, Poisons Commission, that gave birth to that piece of legislation. But it is our submission that that section is underutilized, and as a result, people who are supposed to have been declared dangerous criminals with the attended reviews from time to time are sentenced as normal criminals, I will put it that way, as ordinary criminals in terms of the Section 51(1) of the Criminal Procedure Act. And when their time comes in terms of the Correctional Services Act for them to be eligible for parole, they go through the process and come out. So we are saying that in the process of undertaking this review, we must be able to identify the gaps. And linked to that specifically is that we must not go for the law when in fact we are confronted with the problem of human resources or human capital in the various departments, and find that the reason the minister is complaining about the bail situation. For instance, from where I'm standing, Section 59, Section 60 of the Criminal Procedure Act, with the case of State versus Dlamini, as the judgment was handed down by Krishla J, is that piece of legislation for me is unassailable. But then it depends on the people who are supposed at various levels, the NPA and the judiciary. So our contribution is to the effect that let us not fall into the trap of either wanting to have a response because there's a pressure that has been brought to bear, and we do not do the due diligence in terms of interrogating the two separate issues. The legislation as it stands, does it have fault lines or gaps? Or the legislation as it stands is adequate, but it is the people that are supposed to implement or apply the instrument of legislation that do not do that. Thank you very much. I did introduce myself. I am Sabelo Nobangule. From where? From Nobangule and Partners Incorporated.
Okay. Thank you. Thank you very much. Nobangule Incorporated is a law firm. Okay. Thank you. Thank you very much. Any other rapporteur? Sure, this is not the only discussion that was going on during lunch. Do we have another volunteer? Yes, come, sis. Maybe this will help us to bridge the gap between the ivory tower of the conference hall and the tree Minister Becky Cele was talking about. Whilst we do this, I asked members of the panel, Chairperson of the South African Human Rights Commission, Commissioner Nielsen, to come forward, and the South African Police National Commissioner General Masimola to come to the podium. You have introduced yourself and what your panel was discussing.
Thank you so much. My name is Lohora Dineo. I am from Black Lawyers Association Student Chapter, UNISA, Florida campus. I'm the events coordinator for BLASK. Mine is just a comment. Before we went for lunch, ministers spoke about the victim-centered approach and also the High Commissioner in terms of the technology. So my only concern is that as much as we are fighting crime, in a way, it will increase based on the new education department system. For example, I'm from Flayoff, not far from Florida, the Soweto side. This placement of online application for students who are going to high school or primary is a problem. Where I'm staying, there are students who are staying in Flayoff, but they were placed in Deep Kloof, and it's more than 40 kilometers away. If other students are not placed in schools, they are fighting for space, while others are there. These students are friends. While others are going to school, others are staying at home. It's a disadvantage for those who stay at home to inherit a certain habit. They might be in drugs or alcohol, and their friends who are going to school. As much as it is 80% of those who are going to school, what about that 5% of the people or the learners who did not get space at schools? So my concern is that as much as 80% are in school, that 5% can influence their friends who are going to school, and that can cause a high rate in terms of crime. Minister Becky Cele spoke about the environment. My concern is, as much as he spoke about the environment, if they can look at the issue of old buildings and demolish those buildings, maybe it can reduce the crime, because most crimes happens in those uncompleted old buildings. So my other thing is that in terms of the ex-convicts, there are ex-convicts who served their time in prisons. Now they are out and they were studying while in the prison. They had hope that they will be given a chance to find jobs after serving their sentences. So when they get out with their qualifications and they apply, but they are not employed, that in a way discourages them. And the only thing they might think of, they might go back to committing more crimes because they were given hope while studying in prison, but while they are out, they are not given a platform to show out their skills. For example, I'm doing LLB at UNISA. I know in the legal practice, once you are an ex-convict, you are not allowed to practice. The ex-convicts in communities, they are undermined in a way. As much as they have served their term, now they are out, they are not given an opportunity to show out their skills. Thank you.
Oh, you're doing final year. Yes, thank you for coming to the conference. There's a Solicitor General there. You should get articles next year after you have completed. Okay. Any one last rapporteur before we close? Okay, you can come put quickly. No, you are part of the same constituency, the student constituency. She represented all of you very well. Are you all doing final year? Don't worry about the articles. You are all guaranteed articles.
Thank you, DG. Good afternoon to my learned friends. My name is Charles Mrava from the Big Things Group. I want to say to the members of our group in the table to say I decided to do it because ours is different. It's not a textbook orientated. It's a practical experience of the South African justice system. I want to be honest with you, and I want you to start thinking about justice in South Africa. There is no justice in South Africa. We need to think deep about justice in a country that exists in the African continent. We must start not copying what Britain is doing, America is doing, and start thinking about justice in South Africa. What we were debating is that our court systems, our correctional services, and everything else that we have as laws here in South Africa, there's nothing wrong about them. What is wrong is about Africans trying to behave like they are in America. What is wrong is Africans behaving like they are in Britain. And one of the people who were seated in our table when we were eating lunch, the other one is a former judge, now a practicing lawyer. The other one is a former convict of GBV from jail on bail condition here in this room. Oh, wow. Because you want to practice the law as per what is happening in another country. You're not looking at the information here. One, I'll give you a practical example. If you contest a political position, they can move you with witchcraft. You end up in jail. Anyone believe in me? You don't, eh? You don't. Anyone believe in me? Raise your hand. You don't. Okay. Charles Mrava is a gentleman who was contesting to be a member of National Parliament in this 7th administration. The guy who's standing before you. I was released on bail on the 13th of December. I woke up on the 27th of September with my wife happy, doing breakfast and all that. Because of African magic, my wife started fighting me and wanting to stab me to kill me. You think it's a joke? You think it's a joke? This is how you laugh at us when we come to courts. This is how judges, prosecutors, policemen, and people laugh at us, and you humiliate us. You disrespect us. The only people I can have respect on is officers from correctional service. Because I went to prison. I got to prison on the 11th of October. They listened to me that I'm not mad. I'm an upright man fighting for people in the ground. You don't know me. I've never appeared on TV. You have never seen me. I've served in the African National Congress for over 22 years. I am a member of the ANC in good standing, who has nominated the whole country, who was supposed to be the part of the IEC going to parliament, contesting the same ministers who are here, contesting the same deputy ministers who are here. Today, I'm going to court, a court that is not understanding. My wife is begging them to say, he's an upright man. He has never even killed a fly. And what are judges and prosecutors saying? The law says, the law says, the law. We're saying we are from Lagos. I'm from Venda Day. My branch is in 14 in College Chavani, where they were burning schools. Now what we need is that it's only the chaplain on correctional service who said, I want to listen to you. What is going wrong? I said, you must remember, this is what is supposed to happen and all that. I took a text and started writing and say, this is what we must amend, because there was a reason why I must go through this so that we change. That's why I attended this conference. We need to start making sure that we say, this is the law that we want for our people, that will serve just. Don't just remind. You are actually making people to be criminals by putting them in jail. I'm a breadwinner, and I'm making sure that I'm taking my kids to school. And we're going to that parliament. We're going to change this law. Thank you.
Thank you. Thank you very much. Thank you very much. Okay, ladies and gentlemen, we get back to the program. Panel 2, which will have been panel 1 from the program, and it's going to look at the integrated criminal justice system and some international perspective on crime fighting. We have already taken the High Commissioner of the UK, who has already dealt with the issue of technology. So in our panel here, we have Dr. Ogon from the UN Office for Drugs and Crime. We also have the chairperson of the South African Human Rights Commission, who's going to present on the lessons learned from the July Civil Unrest, that's 2021. And we also have General Fanima Simula, who will deal with challenges in combating, preventing, and investigating crime. Maybe let me start with you, Chairperson. Yes. No, apologies, colleagues. We have just done some slight adjustment. Doctor will take UNODC first, because there's a presentation we should take. You have the floor.
Thank you very much, Program Director, and I would like to introduce myself properly. Many people do have a problem pronouncing my name. I am Jane Marie Ongolo, the UNODC Regional Representative for Southern Africa, based here in Pretoria. I would like to start by acknowledging Honorable Deputy President of the Republic of South Africa, Paul Mashatile in absentia, Honorable Minister, Department of Justice and Constitutional Development, Ronald Ramola in absentia as well, Honorable Minister of Police, Becky Stele in absentia, Deputy Minister, Department of Justice and Constitutional Development, John Jeffrey, Directors General, National Commissioners, National Director of Public Prosecutors, and Judge Presidents, other protocols observed. Ladies and gentlemen, good afternoon to you. It's my great pleasure to be with you this afternoon, and I was asked to talk about key challenges in fighting crime in the 21st century. And I'll briefly speak about these challenges in relation to the work that UNODC does and what we can do together with the government of South Africa. And I would like to start by looking at a very fundamental question related to access to justice. Challenges in relation to access to justice. Who has access to justice, where, and when? Access to justice, as we've known, and I'll be repeating a lot of the things that were already said in the morning, and repetition is good because then we remember. Access to justice is a key component of a fair, humane, and effective, efficient criminal justice system and foundation for the rule of law. Ensuring equal access to justice for all is critical to preventing human rights abuses, crime and conflict, and by reducing inequalities and addressing crises. Okay? So the lack of access to justice and inequalities erodes trust in the fairness of the system, regardless of who that person is who is not accessing justice. It erodes trust in the fairness of the system among potential and sentenced offenders, among victims, witnesses, and the general public, and heightens the likelihood that grievances among the population manifest through violent or non-democratic means. When people feel that they cannot access justice, then they would resort to probably violent or non-democratic means. It is important, therefore, to note that the progress for the 2030 Agenda for Sustainable Development in relation to peaceful, just, and inclusive societies is worryingly low, and partly because of the gap in people's ability to access justice, which continues to be significant, not only in South Africa, but I think the rest of the world. Data is very limited on who accesses justice. But where, for the countries that report, less than half of the population who fall victim to violence do not report their victimization to competent authorities, especially victims of sexual assault. They report less than victims of other crimes. For me, I think that's a challenge. When crimes are not reported, when victims feel afraid to report, how can we address that? So it could imply, the fact that victims do not report could imply continuing overall distrust of criminal justice institutions. Victims' reluctance to seek justice perpetuates cycles of violence and impunity, eroding the foundations of a just society. Recently, a sub-indicator for the SDG was introduced, looking at dispute resolution mechanisms, if that probably could provide an alternative. But again, no country is reporting so far on the usage of dispute resolution mechanisms. Yet these mechanisms are integral to ensuring equal access to justice for all and are essential in supporting individuals encountering barriers to the formal legal system by offering alternate tools and processes to address grievances and to seek redress. So the first challenge I wanted to bring out is access to justice. The second one, crime prevention, or generally the prevalence of crime. Globally, countries continue to face multiple challenges developing and implementing comprehensive crime prevention policies and programs. Often, states put more efforts in addressing specific types of crimes or violence rather than creating synergies across the types of violence. And I think the exercise that we are having today in reviewing the legislation is important in bringing all this together. And I would like to applaud the efforts made by South Africa to develop integrated policies and strategies on crime prevention, such as the 2022 Integrated Crime and Violence Prevention Strategy. I would like also to stress that it's paramount to invest in long-term prevention efforts and to encourage criminal justice practitioners and the system to develop preventative measures. For example, where police forces are more and more using strategic and proactive problem-solving approaches, but also where we have judges more aware of the costs and benefits of a range of sentencing options, including non-custodial sentences, alternatives to imprisonment, and restorative justice, including special needs of vulnerable groups, women and children. Not to mean that all women and children are vulnerable, but disproportionately they are affected by crime. In terms of the prevention of recidivism, international standards prescribe that the principle of supporting prisoners with their social integration to prevent reoffending should be at the heart of prison management strategies and policies. But in practice, however, a large proportion of the budget for prisons is used for security and order, with a small and typically inadequate amount being invested in prison workshop, skills training, and education facilities. And really this talks to what one of the speakers raised. When people leave prisons, if they're not properly reintegrated, they'll reoffend over and over again. So I think then we need to look at community-based prevention, building community resilience to crime and violence. Yes. So one cannot simply assume that communities will and can engage in crime prevention, but they need support of everyone, including support of the criminal justice system. Quickly, the issues I'm addressing are interrelated. Drug trafficking, which intersects quite a lot with the criminal justice system. Effectively addressing drug trafficking and drug challenges in the 21st century requires a comprehensive approach that involves collaboration among various stakeholders, given, firstly, its transnational nature. Therefore, international cooperation is crucial, moving beyond our national systems, but sharing intelligence, coordinating law enforcement efforts, and implementing mutual legal assistance treaties to combat drug trafficking across borders. However, prevention is still very important when we are addressing drug challenges. This includes implementing drug education and awareness programs in schools and communities, as well as providing support and resources for individuals at risk of engaging in drug use or trafficking. Engaging communities is cheaper than actually fighting crime. So when we engage communities in drug prevention and intervention efforts to address overall drug response challenges, they become responsive, and it fosters partnerships between law enforcement, civil society organizations, local communities to develop tailored solutions that addresses the specific needs and concerns of each community. Therefore, I think that it's important that while addressing crimes related to drugs, that we adopt multifaceted approach that combines preventive measures, law enforcement efforts, legislative reforms, international cooperation, amongst others. Briefly describing them. Violence against women, quickly. I am aware of the review of the Criminal Procedure Act that tries to consolidate the changes and improvements in existing legislation concerning gender-based violence. that's important, bringing them together in one act. But I would like to urge that this process goes further to ensure that international standards and norms on criminal justice responses to violence against women are fully incorporated. When it comes to GBV, increasingly we are seeing it happening online, and the mounting evidence that women and girls are disproportionately affected is of great concern, whether online or offline. So while online, IT can be used to perpetrate gender-based violence, but I think technology, as was mentioned by earlier speakers, can also be used to enable the safe expression of women and girls' rights and to defend them. UNODC conducted research which showed that e-justice mechanisms have facilitated access to justice for victims and survivors during and after the COVID-19 pandemic. So still at the legislative reform, while it's a good starting point, criminal justice systems can do more to become more survivor-centered. And one of the things that I know countries do, including South Africa here, a good practice that encourages recruitment and retention of women in criminal justice institutions to provide survivors with their right to speak to female officials. But on the other hand, we need to, that's the first step, having females who can speak in a female-friendly manner to females also affected. But experience shows that promoting access to quality, comprehensive, and coordinated essential health, social, police, and justice services can significantly break the cycles of violence, which often end in femicide. To my last two challenges, violence against women, violence against children, also on the rise, just like violence against women. Member states confront significant challenges in effectively protecting children from crime and violence. But how are they treated in the criminal justice system? The justice systems originally designed for adults fall short in developing a child-sensitive, gender-responsive, victim-centered approach, especially when applying technologies in digital justice for children. And this shortfall arises from a lack of understanding regarding concerns and potential risks associated with uncritically applying technologies in digital justice for children, which lead to the application of may lead to application of measures suitable for adults that should not automatically be extended to children. So that's one challenge. The second one, special attention is required for crimes facilitated by technology, such as online child sexual abuse material and grooming. And then thirdly, the escalating challenges of responding to and preventing child recruitment by organized criminal and armed groups, including terrorists, intensify with the pervasive use of advanced technology and online recruitment specifically designed to exploit children, leveraging their vulnerabilities. So in this regard, what have we done? UNODC, in collaboration with the UN Special Representative of the Secretary General on Violence Against Children, launched the strategy which is called Strategy to End Violence Against Children, identifying 4 critical contexts of intervention during this century, which includes the justice, we are talking about justice, cyberspace, insecurity, and children on the move. I think this strategy enhances innovation, partnership, coordination, and collaboration, integrating child rights into various initiatives. And I think this is a strategy that we can look into when reviewing sections relevant to crimes that affect children or where children are in contact with the criminal justice system. Penal reform and prison reform. I would not end without talking about penal reform. Prison and offender management, including through both custodial and non-custodial measures, in line with the Nelson Mandela rules, the Bangkok rules, and the Tokyo rules, are a crucial yet often overlooked component of efforts to prevent and counter crime in an effective and sustainable manner. As we are aware, many countries continue to be affected, I'm sure here as well, by an excessive reliance on incarceration as the default response to crime, resulting to prison overcrowding, poor prison conditions, lack of access to constructive activities that ultimately undermine rehabilitation and social reintegration. Equally, there's evidence of organized crime or informal prisoner hierarchies expanding their influence and modus operandi in prison systems that are often overstretched, under-resourced, or where insufficient attention is being paid to tailored prison staff training, negatively impacting safety and security in prison and in the community. And I would really like to encourage all of us that rather than seeing alternatives to incarceration as being, or prisons as being soft on crime, an enhanced use of non-custodial measures for certain categories, and we have to determine what those categories are. Certain categories of offenses or offenders as proven to be more effective to ensure accountability and address root causes of offending, while at the same time focusing resources in prisons on those who strictly need to be incarcerated. And I'm pleased to inform you that the international community has started to pay dedicated attention to the issue of recidivism prevention, as evidenced by the ongoing intergovernmental process aimed at developing new UN model strategies on reducing reoffending. This effort is being championed by Japan, and South Africa is engaged as the rapporteur of this bureau. So as I conclude, the mother of it all, corruption, and how corruption intersects with all different types of crime. Despite wide-ranging efforts by many countries, including South Africa, to curb corruption, it remains widespread and deeply corrosive, affecting the criminal justice system, service provision, economic opportunity, social cohesion, and political integrity. And while not a matter of the criminal justice system only, as long as it's not tackled, it renders everything else in the criminal justice system ineffective. It is a factor exacerbating the triple challenges of poverty, inequality, and employment with which the country struggles. Due to its seriousness, the seriousness of corruption as a facilitator of organized crime, a resolution was adopted during the 10th session of the Conference of the State Parties to the United Nations Convention Against Corruption, UNCAC, held in December 2023, and South Africa was very strongly represented there. And this resolution, which was adopted, is titled Measures to Address Corruption Involving Organized Criminal Groups. So why am I bringing this? The resolution expresses concern about the seriousness of the problems and threats posed by corruption to the stability and security of societies, and how these threats undermine the institutions and values of democracy, and also brings in the links between corruption and other forms of crime, in particular organized crime and economic crime, including money laundering. South Africa, being a signatory to the United Nations Convention Against Crime, Against Corruption, we as the United Nations then stand ready to work with the government of South Africa on various measures to address this. And this support or the technical assistance that we can be involved in includes provision of technical assistance to address recommendations made during assessments to review the country's implementation of the United Nations Convention Against Corruption, training to improve its skills and knowledge of anti-corruption practitioners, and support to improve organizational capacities. And furthermore, we can work together towards addressing illicit financial flows, including recovering stolen assets, addressing the harm caused by drugs. I talked about drugs earlier on, the smuggling and trafficking in persons, crimes that affect the environment, and the work to detect and prevent the flow of illicit funds that accrue from these crimes that are really all underway. So really that's my offer, that we can work together on all these issues. So with those very many remarks or the challenges that I've addressed, I hope that we can look into them while reviewing the Act to see where we can strongly plug in crime prevention elements, but most importantly, access to justice for all. So, Honorable Deputy Minister, ladies and gentlemen, UNODC stands ready to provide substantive inputs in support of relevant legislative reforms and efforts. And I thank you for your attention.
Thank you very much, Dr. Ogono. Just a correction on the program. This is not UNDOC, it's UNODC, UN Office for Drugs and Crime. So let's just correct that on the program. Okay, thank you very much. Let me take General Masimula. He has already spoken, but there are some areas of emphasis. I think it doesn't need more than 15 minutes. General?
Thank you very much, Program Director. Indeed, I will be quite brief. My presentation was dealt with this morning, quite, in a police language, I would say it was assaulted by the minister when he was presenting. Let me recognize the Deputy Minister of Justice, John Jeffries, Judge Presidents present here today, all the judges, all HODs, DGs, commissioners, and all conference attendees that are here today. Basically, the challenges that we as police, we go through when we have to do our work are quite immense. As you are aware that we are right at the door of the criminal justice system, and everything happens there from onwards. As you go to prosecution, you go to the judiciary, but we have started with us. And of course, it is the most difficult beginning where things starts. We face numerous challenges, some directly and indirectly, which affect our ability and the effectiveness. Of course, the crime rates in the country, we accept it is unacceptable, even though we do not know other crime rates of most of the countries, which they do not release at all. We do have resource constraints to deliver on our mandate. We recall earlier years that there was quite a time where police colleges were closed, nursing colleges were closed, so it's not only us that suffered, but the greater public service. But now, of course, we have started recruiting, and we hope We know we'll not have enough, but at least be able to have police in street block that will assist us greatly. Because we know that currently people require police. The country has turned into something that will require more police stations and prisons than schools. I don't know whether, like Dube, some 20 years ago, may his soul rest in peace, when he started his song, that I'm a prisoner, where he said, in the future we'll build more prisons and we'll build also more police stations. But as a nation, I think we need to reflect and look at where problems are. As the police, not South African Police Service alone, but the greater law enforcement agency, we are there and will do our best to make sure that we bring criminals to book. But the society also needs to bring their part, because the damage happens at the unit called a family. Once things goes wrong there, and then the family start taking responsibility, shying away from responsibility, giving the responsibility of grooming children to teachers. And teachers will do the same and say, well, this is not, looks a little bit bigger problem, it requires police. So now we are just a limited number. We can't have so many children to groom. We need assistance. So we do have legislation requirements, yes, that we need to change. Like one of them is this Criminal Procedure Act that needs to change. But of course, earlier there was a mention of the Integrated Crime and Violence Prevention Strategy, which if all government departments can play their part, it will make life easier. Because currently, policing service is required by all, but accessibility is a problem. And also to have police to access areas where they must service is difficult. The minister earlier mentioned quite a number of new places in the Western Cape that are there, but there are older places like your Philippi East, Marikana settlement is old. The Kwamashu Amen's hostel in KZN is an old settlement, but however, we still do not have access into those areas. But the community expect that when it comes to services, we must be able to be there. Yes, lucky enough, we have now ventured into technology policing so that it can assist us to access where we can't through the use of drones. But at the end of the day, even if the drones can show you what is going wrong, you still need a warm body to get there. And that is the difficulties and challenges that we are faced with. As South African Police Service, we are part of the integrated criminal justice system and the implementation of the 7-point plan, which its aim was to make sure that there's integration from the beginning of the police up to when you get to my colleague, Commissioner Tubakale, so that there is integration of all the system right through. But unfortunately, we are not yet there. We are working towards to be there. So what are the challenges that we have currently with the current Criminal Procedure Act? Few of them I'll mention, which we are aware that this law has been changed for quite some time. And now that we are here to look at amendments, we appreciate that. Some of the challenges we face includes the use of force in effecting arrest. You would appreciate that for police officials, it takes a few seconds, maybe 3 seconds, to decide whether do I use my firearm or not. But it takes this table in front for quite many years to adjudicate whether you were right or wrong. Hence, we have so many police officials that die with their guns on the hip. You heard Minister earlier said we have 22 for the third quarter, that is October, November, December. But if we start from 1st of April to end of 31st of December last year, we are standing at 88 policemen, 88, of which 32 of them died while on duty, and 56 of them died while off duty. It cannot be normal. Yes, we know. Also the murder rate in the country, we know a lot of people are dying. But I think it will require this House to look quite deeper into it to say what is the problem. Because the problem is police are hesitant. In as much as we train them, we explain to them when to use their firearm, they are hesitant to use their firearms, which they end up being killed in the process. So I'll ask this House to also in the deliberation look at those areas of the Criminal Procedure Act, especially your Section 49 as amended. Probably, I don't know, the new one, what it will be, but we plead that let's look at that. I don't have the answer, but I'm sure this House will have the answer, because whether they are on duty or off duty, they are still being killed for being either police official or for taking action. An example is the one we buried this Sunday with the Minister of Police in Escort, and the one that was buried last Saturday, a week ago in Inanda. All of them were off duty, but they had a noise next door that this is an unusual noise, and they took their firearm to go and assist. And in the process, they were shot and they died. So that's one area that would require quite a lot of assistance. And also, given the unacceptable high level of crime, particularly violent crime in South Africa, it is imperative to carefully weigh the benefits of modern technology in preventing, combating, and investigating crime, striving for a reasonable balance. Reference has been made to the concept of the fifth jurisdictional fact in the context of arrest. This refers to the additional consideration that a peace officer must consider beyond the criteria for a lawful arrest, which involves evaluating whether there are less intrusive options available to bring the suspect to court instead of making an arrest. The previous speaker spoke about non-custodial sanctions, which we think, yes, going forward, as you are here to amend or improve the Criminal Procedure Act, we need to look at that because we heard that my colleague, Commissioner Tuahale, is 44% overpopulated, and that makes their work quite challenging, which as a result, to an extent, you will end up finding that less serious convicts, they learn a lot at the time while they are in incarceration. By the time they get released, they are graduates. And once they are graduates, they will do and behave like graduates when they are outside. And they are not afraid to do anything. I'm sure you know about the notorious place in Soshanguve called Juku Lane. So we discovered that that area has been taken over by these parolees. There are not many, about 7 of them, all of them parolees. but they've taken charge of the whole area. So as we are standing here today, we have arrested 7 of them, but we're still looking for others. Because the life there, they say when you pay lobola, you can marry with 50 rand. Pay lobola with 50 rand and you go. That's how they turn that community into. But so most of such people, when they were incarcerated before, they might have been a minor offense, but the training they get when they get out there make them to be more serious, more confident in committing crime. So yes, non-custodial sanctions might assist in certain crimes so that we do not end up grooming and graduating the society or the country into criminals. But yes, there are those that are committing serious and violent crime, which we think those they belong into, they belong to jail, they must serve quite a good jail time. Coming to bail, I think we did discuss about bail earlier. Our challenge there is solely repeat bail. Having the same person who get bail one after the other for the same crime, especially, as the minister said, for your cash in transit heist. They will carry on and get bail, and the presiding officers of the judiciary will say, but he's always available to come to court. Yes, we agree, he's available, but he have committed one. So can you keep him in so that you don't commit another? No, you get given bail, he commits again. We have people that go up to 30, 35 cases, similar, CIT, but getting bail all the time. So there we surely definitely says, look at the Criminal Procedure Act, maybe you might find something that can assist us. Second one, still on bail, I think I said before, is the appeal bail. When there is somebody get denied bail at, be it regional or lower court, and then they appeal. Once that appeal at the high court maybe, it is always or usually said there are new facts. Now the accused bring new facts. Now why shouldn't the state also listen to those new facts and also be able to respond to the new facts? But in that regard, normally the investigating officer don't get called, and the next thing, the bail is granted and the person is back on the street. We don't say nobody must get bail. No, yes, of course. Well, those that deserve, they must get. But if there are new facts that are being considered on the side of the accused, so let the state also have a response on the very same facts and indicate as to what is the status. The second part in this area of appeal, which is currently also a bit of a problem or a lacuna, is that those that get sentenced, they appeal, sentence and conviction maybe, and they get given bail. And by the time their appeal is heard, when it gets dismissed, the message don't filter down. Even now as we speak, there are many of them that are out there. The investigating officer knows that no, he have appealed, he is on bail. Correctional Service probably knows the same. The registrar of the High Court, I don't know whether he knows or who did he inform, we don't know. So if the new law can, without being ambiguity, but be straightforward as to who is responsible once the appeal is dismissed, who is responsible to go and collect the person. Because normally such people, you find they get caught only when they commit another crime. To find that this person's appeal was dismissed 5 years ago or 8 years ago. So I think it's an area that needs to be considered. The last one that we also want to raise is that, as you are aware that it was said earlier, the Criminal Procedure Act comes as far as 1977. The Constitution was 1996 and other laws, including the Police Act. There is this Section 334 of the Criminal Procedure Act that authorized the Minister of Justice to declare a certain category of people as peace officers. In a way, declare them the de facto police in a way. And, but remember, the Minister of Justice don't have constitutional powers in terms of policing. So maybe in this new law, just see if you can locate it somewhere else, because we have seen a mushrooming, especially at municipal level, where municipalities, they employ these people as peace officers and they call them law enforcement. And remember that the National Commissioner of Police don't have powers over law enforcement. And most of the oversight bodies, including your IPID, don't have powers over the law enforcement. We do, however, have powers over the Metro Police. Now you'll find that some municipalities that are legally clever, they constrain municipal police into very few numbers and increase the law enforcement. So you just have to ask yourself, what are the objectives? So it's an area that I think will need to be looked at as you look at the new law, so that there is justice, there is oversight over such bodies, or the policing powers resort to one area where it should be. But of course also, I think it was explained earlier, look at the issues around the victims. Police, our role is to deal with criminals. But now the current policies and legal framework confuse the police a lot. When they get to a criminal, they must behave in such a manner they deal with the criminal. And when they turn to the victim, they must show a smiling face. So they must always have this double character, which we think it becomes a bit abnormal for any person. Why should we be given this whole responsibility of dealing with criminals? So much so now we must establish victim-friendly rooms at police stations. It's like your miniature hotel at a police station, which is also a risk on its own. We don't know what happens there at the end of the day. We do have, of course, in the government, we have got the Department of Social Development. We work 24 hours. We know that, yeah, maybe they do work some don't work 24 hours. But shouldn't the Criminal Procedure Act give the responsibility of victims where it belongs to Department of Social Development, so that we don't confuse things? We know what we have to deal with. We deal with the criminal, but don't have to worry about buying some hamburgers and tea and whatever, which at the end of the day is quite risky. Yes, of course, people, if they come overnight, we can't deny them or chase them. But same time, nobody denied social workers from the Department of Social Development to be at a police station 24 hours, take care of the victims, so that victims also appreciate that they are being looked after, not only the criminal that we take care of. As it often quite, it always happens that just recently, this Saturday morning here in Ekurhuleni, a certain gentleman decided to hold his wife and children hostage, and the wife's friend came, also hold her hostage. Police were called to say, hey, come and assist, there is domestic violence. They go there, as the previous speaker said, police should be approach this situation with a view to problem solving. So they tried to negotiate with this guy. And guess what? He shot all 3 police. Luckily, no one died, but they are in the hospital as we speak. And still, we must negotiate with him nicely, get the relevant forces, and eventually, he released all people. And he's out. Now we are cutting him in hospital. As it was said, he will get the best treatment where he is. I hope he doesn't get bail, because if he get bail, that wife and those children, they are going to get it. Thank you very much.
Thank you very much, National Commissioner. At some points, I have agreed that the National Commissioner may take leave to attend to other matters of criminals outside. So when you see him leaving, he's not abdicating, but he's going to make sure that crime remains under control. And the colleagues that works with him will remain here to answer questions. Ladies and gentlemen, I have the honor now to call the chairperson of the South African Human Rights Commission, Commissioner Nielsen, to deal with the experience of the civil unrest of July 21. Thank you very much, Commissioner.
Thank you, Program Director. In the absence, the Deputy President, Minister Lamola, Minister Tkele, and of course, all of us, the Deputy Minister Olomisa and Deputy Minister John Jeffrey, Members of Parliament, the Judiciary, colleagues from South African Law Reform, fellow heads of Chapter 9 institutions, the National Commissioner of Correctional Services, National Commissioner of Police, esteemed delegates, colleagues and friends, all protocol observe. Good afternoon. We have been asked to share key lessons from the July 21 civil unrest from a human rights perspective. I will only take a few minutes of your time and then ask my colleague, Commissioner Ntuli, who were part of the panel together with me and Commissioner Gaum. And I'm very happy to see Advocate Tipenyane here today because he was one of the key drivers to make that hearing possible. And Ntuli will share our findings and recommendations emanating from the July 2021 civil unrest investigative hearing. As we all know, the 2021 July unrest, which unfolded primarily in KZN and Gauteng provinces, occurred during a complex social, economic, and political period in South Africa. The nation is still struggling to come to terms with the cost of the COVID-19 pandemic. By June 2021, South Africa had moved from a 29% unemployment rate to a record high, all-time high of 30.4%. It was reported that because of the July unrest, 40,000 businesses and 50,000 informal traders were affected, with approximately 150,000 jobs put at risk. The financial damage of the unrest was estimated at 50 billion. Approximately 353 lives were lost. Following the aftermath of the unrest, the South African Human Rights Commission held a public imbizo as a platform for a collective reflection and reckoning with the unprecedented events. The imbizo was followed by the National Investigative Hearing, which was held from 15 November 2021 to 21 June 2022 in Durban and in Johannesburg, respectively. The Commission inquired into 4 themes: the social, economic, spatial, and political factors prevalent in the various affected areas and the extent to which these played a role in the unrest. Issue 1. The causes of the alleged racially motivated attacks and killings in the country was our issue 2. The third one, the causes of the apparent lapse in law enforcement by state security agencies, particularly in the South African police services, and the role of private security companies in the unrest. Issue 4, the causes of the July unrest, with a particular focus on Gauteng and KwaZulu-Natal provinces, is the number 4. By the end of the national hearing, the hearing panel has had 54 oral testimonies, including from His Excellency President Cyril Ramaphosa and some of the members of the cabinet, and received more than 120 written submissions. Program Director, as enjoined by the Constitution, we expected constructive engagement with the relevant stakeholders to address the recommendations we have made in the report, in this unrest hearing report. We are also supported here today by the 2 newly appointed commissioners, Commissioner Gumbela and also Commissioner Mandlengosi, and by our CEO. I now hand over to Commissioner Ntuli. Thank you, Program Director.
Thank you very much, Chairperson. Good afternoon, Deputy Minister, all guests in the room. We greet you. Program Director, I thought the General Masamola's presentation should come after ours because there are some things to answer here by the South African Police Service. I will speak to the findings and the recommendations of our July unrest report, having been introduced by our chairperson. I begin with issue 1. As the chairperson has indicated, we covered 4 issues. The first issue pertained to the social, economic, spatial, and political factors that were prevalent in the various affected areas and the extent to which these would have played a role in the unrest. The Human Rights Commission found that the unrest was indeed orchestrated through primary actors who were well-resourced and who were led and executed, and who are the ones who led and executed the widespread destruction of property and perpetrated arson attacks. They then in turn mobilized secondary actors, and fellow South Africans, you would be all very much aware of this because it was very well publicized upon the release of our report on the 29th of January. We also found that there was an absence generally of the South African Police Service or other state security agencies. The socio-economic factors did play a part in the unrest, but they were not the cause. The government's shortcomings in effectively sharing intelligence products and information played a significant role in the escalation of the unrest. Through the creation and the dissemination of inflammatory content, social media amplified the grievances, stoked the fear and the anger, and mobilized individuals towards disruptive actions. With regards to then these findings, the recommendations are as such. The Human Rights Commission recommended that the government has an urgent responsibility to address the socio-economic inequalities which were described as extreme wealth in a sea of poverty. Government and the private sector in particular must develop efforts to undo South Africa's colonial economic model. The unrest has also demonstrated the need to create a legitimate, inclusive economy. The government and the private sector should dilute market dominance and monopolization of business industries. Government must also invest in close monitoring and evaluation tools or resources to record and measure the impact upon implementing their socio-economic action plans. With regards to issue 2, which is the causes of the alleged racially motivated attacks and killings in the country, the Commission found that the July unrest created a climate of fear and tension, prompting many people of all races to take to the streets in an effort to protect their homes and their neighborhoods, particularly in the absence of visible policing. Amidst all of this, there was a significant number of racially motivated killings and assaults that occurred at numerous roadblocks, especially throughout Phoenix and surrounding areas in Durban, eThekwini. The level of organization involved in these acts, coupled with the lack of intervention by the mainly Indian police officers stationed at the sub's office, and the racist social media messaging in circulation at the time, points to a larger racial problem within that community. The cause of the alleged racially motivated attacks was socially embedded racism. Now we move to the recommendations pertaining to the causes of the alleged racially motivated attacks and killings. The Human Rights Commission found that the JCPS cluster must be victim-centered, and we were inspired to hear this mentioned also by Minister Cele earlier this morning. In its approach to the victims of the unrest-related racial violence, inclusive of the SUB's Phoenix Unrest Task Team, which was established in the immediate aftermath of the unrest, the KwaZulu-Natal Provincial Commissioner, in collaboration with the NPA, and specifically the KwaZulu-Natal DPP, in the spirit of Ubuntu Boto, and in accordance with the Victim Charter, must advise victims of their rights and recourse pertaining to their status as victims. Mechanisms of victim support in line with the Victim Charter, international principles, and as envisaged by the tabled Victim Support Services Bill, should be considered by the NPA during the course of the criminal procedure and the Department of Justice once matters have been finalized with the involvement of Legal Aid South Africa. This may include, inter alia, enduring legal costs for victims who wish to pursue litigation against the accused for damages, or through an interdepartmental partnership with the Department of Social Development in prescribing psychosocial assistance. We further recommend that in accordance with the South African Human Rights Act, the Commission further recommends to Parliament the adoption or further development of the Victim Services Bill and other law which may fully support and achieve a victim-centered approach which may assist victims towards restorative justice. Victims of unfair discrimination should utilize the equality courts and seek justice against their perpetrators. It is acknowledged that the lack of applications instituted in KwaZulu-Natal regarding the unrest may be due to challenges in identifying perpetrators or awaiting the outcome of criminal trials. With regards to issue 3, which is the causes of the apparent lapses in law enforcement by state security agencies, particularly in the South African Police Service, and the role of private security companies in the unrest, the Human Rights Commission found that the South African Police Service Crime Intelligence, as well as SSA, failed to detect the unfolding unrest, which falls within both of their mandates. By failing to maintain the National Security Council and properly coordinating nut joints, government failed to reciprocate and maintain the respect of the rule of law, and it's expected, as it is expected from its citizens during and in the aftermath of the pandemic, as well as the July unrest. PCERA, which is responsible for the private security industry, has failed to fulfill its duty to effectively regulate the private security sector for the protection of citizens. Absence of community engagement in case reporting and access to justice. During the investigation, it became apparent that the victims of violence were not being adequately engaged by SAPS or by the NPA, nor kept informed of their rights and the processes of the criminal justice system. Further, and despite probative evidence suggesting the involvement of former or current members of the security and law enforcement sectors in criminal activities during the unrest, neither the NPA nor the Department of Justice and Constitutional Development could confirm any ongoing investigations or prosecutions against any such individuals. The perceived lack of action, disciplinary measures, or prosecutions against such persons over the past 2 years are of serious concern to not only the South African Human Rights Commission, but to all South Africans in general. The recommendations with regards to issue 3 were as follows. The Human Rights Commission recommends that the JCPS cluster, which includes the Ministry of Police, the Ministry of State Security, and the Ministry of Defense, should establish a mechanism of effective communication to ensure the efficient sharing of classified security information so as to not hinder the dissemination of necessary information that could aid in protecting the public from events such as the July unrest of 2021. The security sector, which includes the State Security Agency, the South African National Defence Force, and other relevant stakeholders, must urgently develop a national security strategy and provide a draft to the South African Human Rights Commission. The Commission further recommends that the Department of Justice and Constitutional Development, the NPA, SAPS, as well as the Treasury, must make capacity available for regular communication with victims, as well as victims' families, and understanding that SAPS officials and the NPA are acting within the confines of the law may assist in reduction of criticism of SAPS, as well as the NPA officials, as well as reduce vigilante justice. The Commission further recommends that SAPS must compile a full and comprehensive report of all of the July unrest-related deaths and to submit this list to the South African Human Rights Commission. A clear explanation of the circumstances in which these occurred are also to be included. The Commission further recommends that SAPS examines the high number of deaths as a result of police action during the July unrest and implements measures to reduce the risk of such deaths in future. SAPS is required to provide the Commission with a report in this regard. Further, the Department of Justice and the Office of the National Director of Public Prosecutions must engage directly with affected communities and provide transparent and comprehensive accounts of prosecutions and inquests conducted following the July 2021 unrest. The South African Police Service must also be present at these engagements and give account of any pending investigations. These engagements should be convened at least twice a year until the investigations, inquest, and prosecutions have been finalized. This includes sharing a post-unrest report with the NDPP, with the NDPP's assessment of access to justice in Gauteng and KwaZulu-Natal areas, while ensuring a transformative and restorative justice approach. The information shared should strike a balance between the rights of the accused and the rights of the victims. The South African Human Rights Commission found a non-coherence and minimal victim community engagement on the status and cause of the investigations on matters concerning the July unrest. The Commission learned with concern that some families who lost their loved ones in 2021 did not even have case numbers they can use to follow up with the police. The Human Rights Commission therefore avails itself to assist the South African Police Service as well as the NPA in aligning the cases and to also assist with engaging the victim community to provide relief on at least the aspect of ensuring that everyone has a case number linked to their matter, which they can use in following up on progress. Now, with regards to the implementation of the recommendations of the South African Human Rights Commission, we are guided particularly by Section 18, subsection 4 of the South African Human Rights Act, which states, and I quote, "If the Commission makes any findings or recommendations in respect of a matter investigated by it known to the head of the organization or institution or the executive authority of any national or provincial department concerned, the head of the organization or institution or the executive authority of any national or provincial government department concerned must, within 60 days after becoming aware of such findings or recommendation, respond in writing to the Commission, indicating whether his or her organization, institution, or department intends on taking any steps to give effect to such findings or recommendations, if any steps are required." Now I move to some of the interventions that the South African Human Rights Commission has taken post the hearing itself and also post the release of our report. The first intervention is a cleansing and healing ceremony. Many of, particularly the victim community, made pleas with both the CRL Rights Commission as well as the South African Human Rights Commission to assist in restoring or recovering what has been lost where possible, both materially lost as well as immaterially lost. Now, throughout history, cleansing rituals and ceremonies form part of the African traditional and religious cultures. These rituals are still practiced widely by adherents of these cultures. The cleansing rituals are perceived to be vital means of processing grief, experiencing protection from evil, and assuring liberation from fear of evil that would have caused the death initially. The families of the people who lost their loved ones and their lives during the July unrest in 2021 made requests for cleansing to be performed in honor of their loved ones and in ensuring their eternal rest. The Constitution of the Republic of South Africa also guarantees the right for people to participate in their cultural practices and to be given the space to do so. Both the South African Human Rights Commission as well as the CRL Rights Commission have therefore thought it prudent to assist these communities in realizing their aspirations. Consultations with relevant people and cultural experts are currently underway in planning of these ceremonies. The second intervention relates to social cohesion dialogues, especially for the communities who experienced racial violence. In carrying out the investigations, the commissions engaged quite extensively with members of the affected communities. The July 2021 unrest also contributed to already existing racial tensions, especially between the Indian and African communities, in especially Phoenix and surrounding areas. The Commission recommended interventions geared towards cultivating social cohesion and community building for the two communities. The Human Rights Commission, through its social harmony through national effort, known as SHINE, will facilitate dialogues aimed at encouraging peaceful coexistence and harmonious living between the affected communities. The third intervention relates to compensation for the victims. The Commission notes with concern that there has been no attempt at offering compensation of any kind to those who lost their livelihoods, businesses, breadwinners, and properties during the July 2021 unrest. The Commission thinks it's important that relief is provided for the victims of the July 2021 unrest as a first step towards cultivating healing and restoring what was lost materially as well as immaterially. The Commission is exploring ways in which this could be achieved, utilizing available recommended means to restore justice throughout the country. We have also attached with this report, and we will also publish on our website, a media monitoring report to better understand social perceptions and reactions to the investigations and the outcomes of the investigations of the South African Human Rights Commission. Now, in conclusion, while the state has developed redistributive social policies and programs to alleviate poverty and inequality, the levels of inequality and poverty remain a concern. Almost 30 years into our democracy, South Africa is the most unequal society in the world, and an event like the July unrest, even though it may not have been caused directly by these inequalities, but certainly was exacerbated by the high income inequalities and social inequalities that continue to prevail in our country. The link between poverty and inequality and violence and crime cannot be overstated. There's a need to measure and to strengthen our social cohesion efforts. 30 years after we turned our backs on a racialized system, communities still live amongst each other, but with tension against each other, which would have been inherited from the pre-1994 dispensation, and therefore efforts at building relations of harmony amongst the various racial groups as well as ethnic groups that do live within this nation are critically important to the South African Human Rights Commission, and they should be to all of us. Organs of state are therefore encouraged to cooperate with the South African Human Rights Commission to ensure the implementation of its recommendations. Thank you very much.
Thank you very much, Commissioner. I take it that the 60 days is not starting counting today. We're in a conference. We invited you to come and present. So we'll still have a proper day that we must discuss to kickstart the 60 days. This is a conference. So thank you very much. Colleagues, I was tempted to give you a 10 minutes break, but I know what happens. Can I check what is the popular feeling? Do you want a 10 minutes break before we interact? Oh, okay. Yeah, because I'm just the chair, but I can see that the conference is organically managing itself. So I'm giving you a 10 minutes break. We'll be back here at 15:35 to continue the discussion, to interact with the presentations that have been made. Now is 15:25, so 10 minutes will take us to 15:35. That's 25 minutes before 4. There should be coffee outside. My 10 minutes became 15 minutes, so I was generous with an extra 5 minutes. We'll recover it. Okay, my ushers, please get the participants to be back to the room. The Commissioner and the Chairperson of the Human Rights Commission, if you can get back to the stage. I've lost 2 panel members who have to attend to other matters. Okay, I've opened the floor for discussion. May I recognize hands of participants who will want to speak? The lady here, you are recognized. Who else? The gentleman there at the back. Those of you who are carrying roving mics, please assist me. Any other hands? I want to take 5 hands. The gentleman here and the gentleman there at the back, 4. Can I observe any other participant who will want to speak here on my left? At the center, the lady here behind the cameras. Anyone else? Okay, let's start here with a microphone. Yeah. Can you introduce yourself and...
Good afternoon. Good afternoon. I stand on the protocol of those who came before me. I'm Brigadier General Solomons. I'm from the Department of Defense, the Defense Legal Services Division. Program Director, what I had noted is that during the address and incorporation of the JCPS cluster, the Department of Defense was more, I think, recognized in the security role and not actually in the criminal justice process. What I'm trying to say is that in the Department of Defense, we actually have a criminal justice system where we have military courts. Those are not tribunals, those are not disciplinary hearings, they're actually military courts, and the Constitutional Court had settled on that already in 2001. We are not a parallel system to the NPA or the NDPP. We stand on our own and we have our own legislation, but we also from time to time also utilize the Criminal Procedure Act, the law of evidence and a criminal law. I noted that, and maybe this is not completely true, that we are not included in the part of the integrated justice system. Now, the reason for inclusion should be, is tenfold, but I'm just going to mention a few things. In the military, we retain what we call extraterritorial jurisdiction, meaning that if the military deploys and when the military deploys outside the country and a member commits an offense, that member cannot be prosecuted by the National Prosecuting Authority. The military retains jurisdiction over that individual and we prosecute that individual. Within the confines of the border, within RSA, besides the fact that we have to look after the territorial integrity of South Africa, we also must maintain the defense force as a discipline force, meaning that gives birth to our courts where we mete out discipline. There are exceptions to the type of cases that we can deal with in our military courts, and the exceptions are murder, culpable homicide, treason, and rape, meaning we cannot deal with those offenses in the military courts within the borders of South Africa. All other offenses we have jurisdiction on. So, when we are deployed outside the borders of South Africa, we retain extraterritorial jurisdiction. There are many role players that are present here today that actually are aware of what the military does and has been involved in the military. And one of those is Judge Lechodi. We have a court system where we have a court of military judge, court of senior military judge, and a court of military appeals that is chaired by a judge of the High Court. So in all our deliberations, I would like to say that the military must be and should be included based on our criminal justice system that we have in the military. And also on the issues that what affects the general population also affects the military. The military is a microcosm of the South African society, meaning that we are also plagued by offenses like corruption, fraud, money laundering sometimes, sexual offenses, gender-based violence, and a lot of things that have actually been mentioned here today. But one of the things that we've noted, Program Director, is that military officers or military personnel is not included as peace officers in the Criminal Procedure Act, in the definition. We also have a concern regarding Section 49, and our concern is that the military secures the borders of South Africa. We're talking about the land borders, which spans hundreds of thousands of kilometers. We have approximately 15 deployments on the borders. And transnational crime, as our former speakers spoke of, transnational crime is a reality. We're talking about human trafficking. We're talking about hijacked vehicles moving across the border. We're talking about drugs moving into South Africa, out of South Africa. We're also talking about illegal immigrants. Now we have members that are deployed on the border, and that is their sole purpose. They're not working in conjunction with the SAPS. That's their sole responsibility, border security. And there will definitely be crimes committed. It's a very wide border. It's very dark. It's not always light. And people who commit crime always comes to the party armed. Meaning that in the heat of the moment, and when the offense is taken place and the people are armed, what are soldiers supposed to do? Fire warning shots at individuals with the R4, use the R4 to aim for a limb or a hand in order to incapacitate the perpetrators. So whether we need an exclusion in terms of Section 49, or whether we need to have some sort of concessions as members of the military, that still needs to be looked at. Also, we convict members of sexual offenses. We don't have automatic access to the sexual offenses register. We don't have automatic access to the SAP 69s. And I think it goes, same goes to the Home Affairs and fingerprints. If you can just give me a moment. I think I'm going to stop there, Program Director, so that maybe we can mull over some of the things that was raised, and if any other discussions transpires, then we are available. Thank you.
Thank you very much, Brigadier General, for that intervention. I think that helps. You are here for the next 3 days. We'll find a way of continuing to take the inputs from your side as well. 1977, that's a long time ago. It was a different dispensation altogether, and there's been a lot of development, including the role of the military and how you deal with your members. So those areas that you have raised, particularly the intersectionality in relation to sexual offenses and access to the the police criminal records and all those processes, I think they are very important. So the team that is taking the notes will take note of that, but we'll interact with you as we proceed. The next hand there was a gentleman. Oh yes, this gentleman here.
Good afternoon. My name is Bruce Shipalana, a legal advisor in the Gauteng Premier's office. However, I'm asking this question in a capacity as a concerned citizen. The perception that criminals have more or enjoy more rights than victims. It is real. And I want to amplify what was touched on here. I think there is a consensus to some sort that most offenders are repeat offenders. And where I was sitting, the solution to deal with the situation of repeat offenders, we seem to have touched it superficially. I hope by the end of this conference, we're going to have a solid solution to address that issue. Why I am saying that, and I'm not advocating for an eye for an eye. We know the State versus Makwanyana case has dealt with the issue of the eye for an eye. But as it stands, it cannot be that as a criminal, you can take away someone else's rights, including the right to life, and you are granted that right. We've heard Minister Cele talk about the private health care that they're given, private education, 3 meals a day. So to some of these offenders, when they go to prison, they even harness their skills. They're not rehabilitated. They come out even more sharper than when they went in there. And you also hear stories about some of them even feel safer in prisons than when they're outside because they've got private protection by the correctional services. So what I'm saying is maybe we need to look at our constitution as it stands. It cannot be that the perpetrators of crime enjoy 3 meals a day, get private facilities, while the victims get to suffer outside. And taking into consideration the Makwanyana case, it could be something that we need to revisit. And because if I'm a criminal, I know if I take my neighbor's car, or even if I kill my neighbor, there's nothing's going to happen to me. I'm going to save time. I'm going to get 3 meals a day. I'm going to get all these facilities. It's no longer a deterrent. Some of them have laptops, have everything inside. It's just life as usual. So what I'm saying is we need to relook at that. When you make a conscious decision to commit crime, you are signing away your rights. You cannot take away innocent human beings' rights, whereas you are guaranteed your rights when you are in prison, and it's like a paid-up hotel. So I am saying let's relook at that, and let's give more rights to the victims. Let the criminal understand and feel that when you commit crime, you are signing away your rights as a criminal. Thank you.
Okay, put differently, you are saying we must reconsider bringing back the death penalty. But you yourself, you are not brave enough. You don't have the courage to master your own convictions and make this point. Oh, okay, all right. There's the gentleman there that I recognize at the back. I think the microphone is off.
Okay, thank you very much. Mdu Shabangu from a community-based human rights and paralegal organization. I'm standing here to say I actually appreciate what the Human Rights Commission was presenting before us, and they have taken some of the things that I intended raising them with you. However, there are issues here. I'm a messenger. Please don't blame me. I'm only a messenger. The question they are asking from the very same communities that we serve, they ask this question as to for how long shall the women die with their protection orders under their mattresses? Meaning to say that we need to find a way while we are waiting for the court appearances. Some mechanisms has to be done during that period, just before the appearances. Those are some of the issues, because it doesn't help to go and apply for the protection order, whilst at the very same time, you are sitting or staying with the very same person, or the person can come at any time without any protection from the local police. The second one being that of a bail. The bail, there are requirements for somebody to can get a bail. But as things are going on, I think we need to strengthen the criteria or the requirements thereof. Among others, to say, if the suspect provides a residential address, that residential address has to be verified in different ways. You cannot give a bail to a person who stays in a shack that worth less than 1,000 rand, and you call it a residential address or a permanent address. You cannot as well grant a bail to a person who is staying in a flat. The second neighbor of that person doesn't know even this person, even if you can go as an investigation officer to say, do you know this suspect? He says, I don't know this person I'm seeing for the first time. But you tend to believe. The court will believe that the person qualifies because he has provided with a proper address. That cannot be on. That cannot be. Some of the people that have been granted those bail don't have maybe even the identity document, right? But the person gets the bail. That's where the problem is. And over and above that is that what do we do when the witnesses, because the police, they are always being told to read out the rights of the suspect. But the rights cannot be read to the victims. Why? Those are some of the things, some of the aspects as we talk about the victims' empowerment, to take that into cognizance. Also in terms of the transportation, that the court will provide the transport cost. It has to be explained to them. It has to be explained as well as their rights during the process while we are waiting for the court hearing. Why don't we also, you are talking about integrated system, justice system. Have we considered the courts that Ubabu Tsele spoke about under the tree? Because we need to integrate our traditional courts with those Western courts that we have adopted or which we were made to adopt, so that the situation or the conditions should talk to every citizen in this country. Because we've got people not only in rural areas, even in the townships we do have amakos who are also presiding. And what I like about their courts is that you report the matter to them today. Tomorrow, they are likely to subpoena a person or to summon a person to come forward. The matter will be dealt with within a day. Finito. Unlike our so-called justice system, there is a motto here: access to justice for all. There are so many barriers to access justice. One is that of also the language that is being spoken in court, right? What is the use of a Latin language in the courts? What is the use of legal precepts that are being used so that we don't understand? We are the lay persons. We end up not understanding what is happening. And yet the motto, access to justice for all. And we also have a challenge with our police. They haven't been trained enough to can deal with the crowds. Now I need us, maybe here or somewhere else, to come out with a better mechanisms as to how the police should respond where there is a crowd. Ubabutele also spoke about a differentiation between those, for example, fees must fall. You understand these are students, right? What about hooligans on the other side? Whenever they are grouped themselves, they are doing other things. Their approach should be different. We should be treated as such. But unfortunately, we also entertain party politics, where if a particular community is protesting and you realize that these people are wearing certain T-shirts associated with a political party, then you are told to deal with them accordingly, which is wrong. So those are some of the things that we need to look at. Like I said, I'm only a messenger, don't blame me.
I take it that you want to make a last
The last one.
Yes.
The last one, please. Somebody here spoke in passing about the TRC. But what do we say about the TRC recommendations? 30 years into democracy, we haven't as yet implemented those recommendations made by the TRC. The question will always be, why? Because those are some of the issues. Some people have spoken loudly and clear to say some of the crimes are socio-economic. Those are the issues that we need to go. We shouldn't just speak as if we are from America or from Britain. We are in South Africa, and we know very well where we're coming from. Thank you very much for that.
Thank you very much. We note the disclaimer that you are carrying a message, and you have best represented the people who gave you the message. Thank you very much. Yes, the lady here.
Hi, everyone. My name is Pindile Cele. I'm from Exit Solutions. Deputy President spoke about the victims and empowerment programs. He also spoke about the early interventions and the victim support interventions. For me, I would like to talk about the offenders and empowerment programs. We all know that in criminal justice, there are so many activities. It's Ingoma, Fundamzansi, Art and Craft. But the only thing that I'm interested in is when an offender has to go home. Now they are having all these activities. They've done even the sewing, others they are fashion design. What actually criminal justice do to make a follow-up? Are they continuing with those skills, or is there any organization that they are working with to send these people to the organizations? Remember, even if us, when we are at home, we are getting bored. So for them to keep busy, I think we need criminal justice to tell us, once they were given the skills, when they are going home, what exactly they are doing to make sure that they are using those skills. Because with the skills that they have, it's a scarce skill. Everyone wants to be a mechanic. Everyone wants to be an artisan. But guys, let us know those skills bawasebenzisa kephi, because even I was checking they even a program called Funda Mzansi. Those programs are limited even to the public. Criminal justice must allow even the public to go there and see this beautiful thing that is happening in their department. Thank you.
Thank you very much. Yeah, that was the gentleman there at the back. I'm observing growing interest on my left.
Thank you very much, DG. My name is Mtobeli Kolisa. I'm from the South African Local Government Association. I want to make inputs on two topics related to the first part of the theme of the conference. which is integrated criminal justice system. I'm not going to talk on the part that relates to review of the Act. And in that regard, I want to just raise 2 points in relation to that. The first one is the point that was touched on both by the Minister and the Commissioner on the issue of environmental design. And more specifically, I want to focus on the land grabs that result in settlements such as COVID-19, such as sanitizer, and others that the Minister mentions from time to time. That is the original problem. That we have had a huge scale of illegal land occupation. And as local government, we've been raising that we need law enforcement to help us with this, but it has largely been in vain. So it's only in cases of municipalities that have municipal police that have been able to do anything about it. Other than that, there's not much that can be done. And even then, as you know, the COVID-19 and sanitizers and so on are in the city of Cape Town, which does have municipal police, but it is overwhelmed because the municipality is on its own in terms of dealing with this. And it is an organized occurrence. For example, during the lockdown of COVID-19, where there were regulations that were saying that if somebody has been occupying a piece of land or a building for more than 72 hours, that person cannot be removed without a court order. And criminals organized themselves to make sure that in one given night, they would start occupying different parts of the city, knowing that the capacity of the city will not be able to remove them within 72 hours. And then there has to be a court process that leads to a court order. And in the process, those areas then grew in terms of settlements. These are the settlements now that we are talking about. I'm raising this particularly from the point of view of the police, that if we don't see it as our priority to help municipalities in land grabs, we are reproducing an environmental design that comes back to bite us. So maybe let me rest that point there. The second point I want to talk about is one that I want to situate on the broken window theory, which says that where there is disorder, apparent disorder, and nothing is being done about it, it is likely to lead to more disorder. Where you have a building with broken windows and no one is attending to it, it sends a message that no one cares, no one's in charge. And it leads to more lawlessness taking place. So that's the situation. Here, I want to talk about the issues that relate to municipal bylaws and the enforcement of municipal bylaws. Currently, the Act, the Police Act, allows for the establishment of municipal police. But such municipal police have been authorized only for 8 municipalities out of 257, which is at the metro municipalities. Other than that, there isn't a municipal police that isn't authorized. But the real problem is where you don't have those being authorized to exist, what then is an alternative for those 249 municipalities that don't have that power to have municipal police? The function fulfilled by the existence of municipal police, what is it supposed to be fulfilled with? So it's something that I think we need to be thinking about. And linked to that is the issue of municipal courts. A colleague was sharing with me here that actually even in the courses in academic qualifications for people who are doing law, the procedures of courts do not even touch on municipal courts. In fact, municipal courts in many cases just simply don't exist. And those are the courts that could assist us to take off or to deal with the issues of bylaw enforcement so that illegal dumping does not have to go to a magistrate court and therefore be delayed there. It could be addressed through a municipal court. So the point being that There is a gap both in relation to policing municipal bylaws, so we need to think about what do we do about that. And secondly, there is a gap in relation to municipal courts for the enforcement of bylaws where there are disputes between the municipality and the perpetrator in relation to the enforcement of the bylaws. So I thought I should raise those two things because I think if we are to talk about integrated criminal justice system and we think about the broken window theory, we might have to attend to those points. Thank you very much.
Thank you very much. The two hands I've seen from this side, I'll strictly manage you. I'm giving you 2 minutes. The British High Commissioner has left here. The British diplomats will tell you that if you can't tell your whole story in 5 points, then there's a problem with the story. Advocate Tipanyane to be followed by Ms. Daniels. 2 minutes.
Thank you, Chairperson. Tipanyane from the Office of the Chief Justice, but I'm speaking in my personal capacity as a former researcher on criminal justice system. Chair, I think that we need to be a bit more realistic. Einstein said you cannot keep on doing the same thing and expect different results. 30 years later, crime is going up. We hear the police saying we need more police officers, more police stations. Clearly, it means the system is not working. We inherited a Western-based criminal justice system. It's not working for us. And therefore, I'm urging that we do need to take some time and really come up with a new South African criminal justice system, which takes into account our own African systems, some of the positive values there. Our own constitution says we must also embrace traditional law in our system. So when we talk about criminal justice system, are we only talking about the Western system or a holistic system? And therefore, we don't need more police officers. We already have 60 million South Africans. Under our African systems, we can actually be our police officers. We're not even investing enough in community policing. So my appeal, Chair, is that can we please press the reset button and design a better system which will suit us as South Africans, not the inherited system which is actually based on imprisonment with no solutions at the end of the day. Now, in other parts of the world, in Sweden apparently, they're actually shutting down prisons because they don't have enough prisoners. So what is working there and why is not working here? So honestly, this approach of simply focusing on a capitalist approach to a criminal justice system is not going to work for us. Thank you.
Thank you very much. That's profound. Ms. Daniels.
Good afternoon. Thank you, DG. I just want to make an emphasis on the protection orders. My view or assessment around the protection orders is the fact that people are making a game out of how you would, of course, ask for a protection order. Then the other one will do a counter, then it becomes a game. But in the end, one of them will die. And then number two, the GBV towards men, it's becoming, and it's getting serious. Currently, I'm dealing with a case that is in the VAL, and unfortunately, things are not yet at a stage where we can say it's now okay. They are still not being attended to. And then my last point would be, is there a way that the department can help us making this GBV issue a priority in the court levels? I'm saying this because from SEP's level, which is your police station level, we have managed to change a lot of things. Maybe I would give them 70%. But when we get to the court level, it becomes a totally different issue where I would rather ask, can't we have magistrates that will concentrate on these cases and to be able to see the trends that are happening? I'll just give an example to say, there's a new trend now that started in the Western Cape whereby a girl gets to be raped and they force them to wash, like take a bath after they wash you. Thank you.
Okay, let me take the lady here. You're the last hand. No, National Commissioner, don't worry. From the ground, you are the last hand. I'm recognizing.
Thanks, DG. I'm the last one and the shortest. I just have a question. Do we have state security here? Are they invited? And the reason why I'm asking
Do you honestly want me to answer that question?
No, don't answer me.
Okay.
All what I want to say, my comment is that if we want to intensify, if we want to strengthen this criminal justice, And now we've got defense that are saying we are here. Can we also have a positive response that they are here? Then I am happy.
Okay.
Thank you, DJ.
No, they are here.
Thank you.
Okay. I got 15 minutes before we finish the conference, because the conference program told me that we are finishing at 4:30. So I planned my life around that. I will take a few hands that will be helping us to sort of narrow down the discussion. I will take the National Commissioner of the Correctional Services. I will ask J.B. Skosana for 1.5 minutes. I don't know from the judiciary, from the magistracy, I know, JP, you have said everyone has copied you that you have come to listen. Can I have, if it's possible at all, to have one from the judiciary who can comment on some of the things? Then I will give Deputy Minister John Jeffrey 5 minutes to make sense of the discussion we are having. Just one point that maybe I must mention. The Traditional Courts Act has been signed by the President, has been assented to by the President. What is outstanding is the regulations. Once we are done with the regulations, we'll put it into operations. I know about the monetary jurisdiction, it's 15,000 rands. But you understand we have to deal with many other things as well, what type of a crime and so on and so forth that can be dealt with. But the fact that now we have an act recognizing them, and unfortunately the Department of Justice, or fortunately, I don't know whether it's fortunate or unfortunate, and constitutional development has to take responsibility as well. I don't know whether that will lead ultimately into the integration. But I think the important part is that it will lessen the burden of the magistrate court to a great extent, that those issues that can be dealt with there will be formalized and be dealt with there. National Commissioner?
Yeah, thank you, Program Director. Now I regret the invitation you gave me to join the panel earlier. I thought also I will take an approach that gives the conference an opportunity to reflect on the correctional system, because it would then help one to understand the depth of the understanding of the content and the context of our discussions in this conference. There are two aspects to the discussions. The first one is integrated criminal justice system. Of course, the issue of the review of the Criminal Procedure Act is at the center of this. But then there's a sub-theme, Program Director, that reads strengthening the criminal justice system to keep our people safe and secure. As part of the content documents of the conference, there's a 7-point plan of improving the criminal justice system, and all departments of the Justice, Crime Prevention and Security Cluster contributes to that. The report itself states that in as much as departments have done a lot of work in ensuring that we implement the 7-point plan, integration is still an issue. The report even says that we have not even developed a shared vision. So it's, for me, we need to address that, because it is at the center of the, what I would call not integrated inputs that are made in the conference today. The second point is the point that was made by the chairperson of the cluster, Minister of SAPS, who indicated that we still have not even started in essence to implement the National Crime and Violence Prevention Strategy that was adopted in 2022. So in as much as this conference is about the review of the Criminal Procedure Act and what I've mentioned as sub-themes, we need to send a very strong message to government as government on ensuring that these two programs or plans or strategies gets implemented. Now, there has been a resonating voice about the criminal justice system addressing more the issues of the victims. I would prefer that when we talk more about that, we also talk more about what we are doing in our different spaces, whether it's a private legal practice, whether it's the Department of Correctional Services, police, justice. We talk, and in my view, if you are to talk about what you are doing in addressing the issues and the concerns of the victim, you're going to talk about a particular location. Because crime takes place in a particular location. The criminal justice system processes expresses themselves in a particular location. Now, I do not necessarily want to give a report card, but last week Friday I was at Komati Port in the border of Mpumalanga and Mozambique, where we sat down with young people because in that locality, young people are the drivers of crime. And this is what we were told by the community in the first engagement we had with the community. We sat with these young people, we developed a plan that would move them away from crime. They were complaining about skills development, they were complaining about the recreational facilities, they were complaining about youth development programs. We developed a plan with young people, the private sector, and other government departments. And we were the initiators as the Department of Correctional Services. Now, at the center of implementing that plan is parolees and offenders. There's a lady there who spoke about offender skills programs that we have. One of the parolees there is actually a fashion designer who offered to teach young people fashion designing. The only thing that we needed was how do we make that happen? Of course, at the center of that is the traditional leadership, because we went there through Chief Mkedlana II, who's also a young person himself. Now, and as part of that program, we also looked through, as part of profiling the community, who are the victims of crimes, what kind of crimes, the families, what is it that they need for us to improve their living conditions, but also make it a point that they have access to government services, but also they have access to opportunities that the environment can present. Now, for me, that is implementing the crime and strategies that one has spoken about. But for me, that is addressing the issues of victims directly. Now, there is information that gets shared in conferences, like, for instance, we give offenders, we allow them to go to private hospitals, and we actually are in court with a number of them that want to do that, and we keep on saying in court, they need to get access to clinics that are there in correctional facilities, because we understand why they want to go out. Is to stretch the system and present more security threats and risks to the system. Now, there's also information that is shared about offenders living in hotels and all that. We welcome members of the public to come into correctional facilities and be exposed to the conditions that offenders live in. But most importantly, be exposed to the rehabilitation and corrections programs. The minister, when he was responding to the debate of the station, on the State of the Nation address, and I would like to invite the conference to go back to that speech, he had a theme that was talking about the fact that offenders work there. We have farms, we have workshops. If you go back there, if you just walk back there, there are paintings that have been produced by offenders. One of the conference attendees here bought 3. They are priced. We are developing the arts and culture market through offenders. And as they leave our facilities, they go into communities as parolees. We do the aftercare program. They then get to impart those skills to communities as part of contributing positively. Now, there are positive stories to tell. It's good to be critical, but I think I want to urge that maybe what we also need to do is to get closer to these systems so we understand them better. So when we stand up and speak about them, we speak about what we exactly know. Yes, there are problems of the parole system. Yes, there are problems of reoffending, but there are offenders that even as I'm standing here, some of them have been cleared to sell their art effects overseas, a piece at more than 500,000. And those offenders, those parolees, are contributing immensely into ensuring that crime prevention strategies are implemented. So I thought I need just to share a light on that. I have not even spoken about the number of correctional officials that are responsible for security. With the population of 155,000 and you have 28,000 that are responsible for security, our ratio is 1:6. And you still have to take the likes of Thabo Bester to court. And at the same time still make it a point that those that are not going to court go to farms, they go to workshops, they go to the local clinic within, and in the meantime, they don't attack officials. Now, the presentation by the Minister of Police, you can apply it to officials in correctional facilities. Over lunch, we were talking about one incident, and I will sit down. One of our heads of centers in Waterval survived an assassination attempt coming from work. 11 bullets pumped into the car. A lady who was attacked because she took a firm decision to remove one of the dangerous offenders from the Waterval management area that is in KZN to Kokstad, which is our super maximum facility. Because of that decision, which is not necessarily her decision alone, it's actually a decision of the Department of Correctional Services, she was nearly killed. Another one who took the decision in Mpumalanga did not survive. He was shot as he was leaving his house, going to work. The first person to see him lying down and losing his life was his son. So we need to understand the totality of what we are dealing with as the practical conditions that we are applying, the legislation we want to review, the policies we have, and so that we can be able then to map the way forward in terms of how we can reduce and combat crime in this country. Thank you for the indulgence, Program Director.
It's always a pleasure, Netcom. JB, I've reduced your 1.5 minutes to exactly 1 minute. I'm left with 3 minutes of airtime for the conference. Hey, Madoda, where is the gentleman who is moving the microphone? No, switch it on.
Okay, no thanks, DG. I'm going to be very quick. I think so many things have been said, and like JP Lohodi, we've been keeping copious notes so you can put them into the new bill, etc. But just to mention 3 points quickly. One, I think we must be mindful that the CPA was enacted before the country ratified the African Charter. Now, immediately after the African Charter, there was the United Nations principles and guidelines on the right to a fair trial. Those guidelines are more specific and relate to African countries more than what is in the Bill of Rights currently today. And I think they will help to bring in forward the whole issues of the Africanization of the criminal justice system. The whole notion of the ADR, which is misunderstood because people think that it's a reduced method of resolving disputes. It's part of the African traditional justice system that needs to be taken to this point, etc. The second point is that the 7 points plan still remain relevant today for driving this process. I think we need to be mindful and acknowledge that not much has happened around that process. I've been noting what the ministers have said. One critical element, the 7 points plan by cabinet introduced the whole integrated approach and cohesion. But since 2008, that objective has not been reached because we have looked at the 7 point plan from the point of modernization. Then create an IJ system that will link the systems. And issues of governance and control and planning have been left to the individual stakeholders in the JCPS. And Mr. Kala said that today, that we are still trying to work together. And we hope to find the thing. And Chair, if you don't create a mechanism in legislation that will deal with all notion of governance and control of the system, you won't win the battle, because they still see themselves separate. The Minister of Police arrests, the Minister of Justice releases, the Minister of Correctional Services feeds the prisoners. They see that way. But once you create an integrated approach, you can basically see all ministers, all DGs, all officials speaking from the same line of command, that are all the same. The concern of the overcrowding will be the concern of the Minister of Police, even when they come with the whole notion of the crime bust in terms of the arrest people, etc. Not that those must not be conducted, etc. Last point, the Rome Statute, which, by the way, I'm very glad that we eventually not moved out of that dispensation, create a very progressive provisions on the treatment of victims and witnesses. Many countries, including Kenya, adopted the whole chapter into the Criminal Procedure Act. They never went to go and start elsewhere. That act binds us, the Rome Statute. But even till today, we don't have legislation that protects witnesses. They are dependent. How can we have a program like the Tuduzela care centers, which basically one runs on a voluntary basis on donor funding, and we support witnesses, and you see it nowhere in legislation, but the ministers continue to go and launch the Tuduzela care centers. And those centers, or those measures, are part of the Rome Statute, and I think this process will help us to see what can we take from that process and add into this process. Lastly, I think there's quite an avalanche of jurisprudence on Section 35. And that's why the JPs and judges today have said they've come to listen, because they've given you long enough in judgments to put into legislation. I think this process must go to that level, where we can basically analyze the jurisprudence and get the participants of the practitioners. In a crisis like this, you need the criminal practitioners who are in court every day on those matters to come and give their inputs, because they know exactly where are the loopholes, what are the challenges, etc. From a practical perspective, the loophole of 14,000 convicts which are roaming the street, it's a small issue. It's because once the person gets convicted and sentenced, the police stamp the docket late. The case gets reopened at the SCA and the appeal court as a new matter under the OCJ through a different court system. And what the accused people do, they lodge an appeal, pay bail, and the appeal collapse. It got struck off the roll, and it's struck off the roll on a system separate from the DOJ, on the OCJ. By the time that warrant goes to the police, the docket has been filed, it's a new investigating officer, they don't know where the accused stays, they don't have no clue with the case, etc. That is what causes this kind of challenges, etc. So those are systemic problems that we can all address, not necessarily through legislation, but through them improving the mechanism and the IJS program moving forward. Thanks, DG.
Thank you very much, JB. DM, I hijacked you. I ambushed you, in fact. Yes, I wanted you to...
Okay. No, just because we've gone over time. Let me just highlight two issues. The one was the issue of municipal courts. We do have, or we used to have, community courts in, I think, Cape Town and where was the other place? Was it Joburg? Which was meant to deal with minor, I mean, they were magistrates' courts, but they were meant to deal with minor cases. I think they ended up continuing with the normal district court matters. However, we do have municipal courts in the sense of, in some municipalities, and this would be to the Salga people, it's mainly Western Cape, Cape Town, Stellenbosch, Hermanus, George. The municipality will say to the department, look, we will pay for a court to deal with traffic offenses and municipal bylaws. Sometimes they even provide the building, and they provide the staff, and we appoint a magistrate to act there who they then pay. And I think the NPA will give that person, somebody from the municipality, delegated powers to prosecute. So there are those courts, but they're more dependent on the municipality paying for them. But that's something that can be teased out more. The other point I just wanted to raise was just on GBV, which there's a lot that can be said. And the difficulty with GBV is that, yes, while men are victims, it's predominantly women that are the victims, vast majority. So I know when I address men, they will say, no, we're victims too. But if you look at the stats, it's women who are the victims. And the problem with that is that the victims are people that we all know. Somebody's partner, somebody's father, brother, etc., etc. So it's very much a societal problem. What we've tried to do with the domestic violence orders is, yes, you get a piece of paper. It's just a piece of paper. But if you break that order, then you can be arrested. And we've been trying to tighten it up. And the 2021 amendment had some innovations. So where the complainant and the perpetrator were living together, that the court can issue a protection plan which the police must monitor. I don't know how much that has been used, but those are the kinds of things. But the difficulty we've got is that it is, you know, couples in a relationship, those kinds of things. I mean, I've said, and this won't be very popular with half the hall here, but I mean, the way to solve domestic violence, and yes, as I say it, I know it's not practical, is to say, okay, we'll lock up all the men, all of us, me included, and then there won't be any more gender-based violence. But that's really not practical, I agree. But that's the problem with domestic violence, is it's people in a domestic relationship that people know each other, and how does the state intervene? It's much more difficult. We can't police people's bedrooms, for example. Thanks.
Thank you very much, Deputy Minister. What I will suggest to the conference managers, tomorrow the program starts at 8:30. If you could just take maybe the first 30 minutes, 15 minutes, just have a presentation on the 7-point plan, and take the next 15 minutes and do a presentation on the integrated crime and violence prevention strategy. I think it will just help as well to set the scene and to have the conference participants informed of just the basic pillars of those two documents. Ladies and gentlemen, what is left for me, first I must apologize that we have overshot the time by 7 minutes now. I would have wanted us to finish on time. I know you are busy people, you have schedules, and want to thank all of you for having been very good participants. The success of a program director depends on the participants. The participants can mess you up and you become a hopeless program director, but you were very great. You deserve a round of applause. And as for me, this is where we come to the end, and we'll see you tomorrow at 8:30 here. Thank you very much.